Okay, hello everybody. Welcome. Welcome. Hello. Hello. Yes. Hi. Welcome. Welcome everybody. Let me just take a minute or two here to finish getting set up. I hope everyone is having a good night tonight. Welcome everyone. Thank you for joining me tonight. Just taking a minute here to get everything set up into place. Yes, we did have an arraignment today, didn't we? Yes, the 14th Amendment, Section 3. I will go into that here in a little bit. Yes. Yes. Tonight, I really want to... Hello, welcome, everybody. I'm coming on just a little bit earlier than I had planned, but I wanted to kind of catch a few things so we can talk about a few things that I think are really important to this case. I've heard a lot of questions kind of being put out, and hopefully I'll be able to get in some answers for people's questions tonight when it comes to the First Amendment and how we deal with the First Amendment within the context of criminal cases. So that's really my primary goal tonight. Hopefully we will hit that goal and be able to talk about that. So welcome everybody. Yes, the First Amendment. Oh, how's the nail game? Not as good as I had hoped, but I was in a rush, so hopefully they're not too bad for tonight. But yes, I'm having an okay day. So far, so good, so that's always good. Freedom of speech, yes. Yep, we're going to talk about a lot of issues that come up with freedom of speech and how we regulate freedom of speech in the United States. So we will be getting into a lot of those different issues. Oh, thank you so much. Yes, and there's been a lot of issues about that. Oh, thank you. There have been a lot of questions being brought up about freedom of speech and how it applies in this case. So I wanted to kind of go through the statute and kind of explain how everything works. Well, hello, Real Deal. Good to see you. I think we have a lot of questions when it comes to the First Amendment. That's true. It's not a get out of jail free card. I don't do TikTok battles. I work so much battling in my regular life. I'm kind of off the clock right now. So this is just additional fun for me. So it really is the essence of the government versus the people. Absolutely. Absolutely. It's not a First Amendment issue. Well, I didn't think that it was a First Amendment issue until a lot of people started kind of bringing it up, and it seems to be a pretty big talking point. And so I wanted to kind of go through our First Amendment analysis just to remind everyone of kind of how the First Amendment works. And just to refresh everyone, I'm sure lots of people have a pretty good idea, but I thought let's just go ahead and go through some of the case law and some of the issues when we're dealing with the First Amendment. And I will be actually going through the facts as they were set out in the indictment and kind of comparing some of the evidence here to our First Amendment doctrine, and just kind of taking a look at that, and then you can kind of assess how you think if it's set out properly or not. But yes, how would I represent him? Oh my gosh, I'm not sure. I think probably what his attorneys are doing is what they should be doing. They've already filed motions to seal and various other things. But as defense counsel, you really just kind of try everything you possibly can, see what works, and kind of argue it out. So, we are just kind of looking at it that way. And I think they're doing, yes, discovery. And we're going to get a lot more information in once discovery is made available. And that is a constitutional right under the Brady versus Maryland case. So, of course, yes, discovery. Yes, we're going to see discovery. We don't need discovery in order to go through with an indictment. Of course, discovery is that process in criminal procedure that allows us to go forward and collect information. So until a suit has been filed, there is no discovery. And until an indictment is put out, from the grand jury, we didn't have a case, so there was no discovery. So going forward from today's arraignment with the not guilty plea, then there will be, of course, discovery. So we will see what happens. Yep. Intent is very important. I'm going to kind of talk about the evidence that's in the indictment tonight and kind of put that into our First Amendment analysis to kind of explain that a little bit, to kind of make that a little bit easier. I also wanted to talk a little bit about how the rules of evidence work. So I'll get into that as well a little bit. But yes, I really want to talk about free speech tonight. I think it's one of our most misunderstood rights that we have. So we're going to talk about how that goes through. So, well, B, there is enough evidence of probable cause. Now, is there evidence of proof beyond a reasonable doubt? Well, no, absolutely not. This is the indictment. All we need is probable cause for the indictment. So we do not have proof beyond a reasonable doubt, but we do have probable cause. That's why the jury came down with that. Right. Yes. Oh, of course, Mary May. Happy to. My favorite Perry Mason movie. Oh my gosh. That's pretty old school. I'd have to, I'd need a little bit of time to think about that, I guess. That's pretty old school. Evidence of him playing. Yeah. Yep. Yes. And see, that's what we're going to talk about tonight. We're going to talk about freedom of speech. That's exactly our topic. So there's been a lot of questions about, were some of the things he said freedom of speech? Did they fall under the First Amendment and therefore he can't be charged? And I understand a lot of people have questions about that. So I'm going to go into that tonight and kind of explain that that principle that's been set out. So yes, so we will kind of go into those issues here. Now, grand juries, hold on just a minute here. icon dude. We don't, grand juries are the citizens of this country, so they are drawn in and asked to serve on a jury just like anyone else who gets called for jury duties. So let's kind of try to be just a little bit respectful, please, of the grand jury, because they didn't have a choice. Their numbers were up, they were put in, and it's part of everyone's obligation. So that's true. There is not proof, Brandon, beyond a reasonable doubt. Absolutely. That is absolutely correct. We have proof of probable cause to go forward on an indictment. We do not have a trial to go forward on at this point, so we just don't have that. Yes, so yes, I'm going to go ahead. Well, perhaps. I'll go ahead and get started here. And again, what I really want to do is go through the facts listed in the indictment, okay, and kind of compare those, kind of plug them into our First Amendment doctrine and clarify everything. So, yes, I have posted on the Brandenburg versus Ohio case. That is the leading case when it comes to freedom of speech and any kind of incitement into lawless activity. That is the standard that we use. So that is the case I will be going through tonight when I'm kind of pulling out these different pieces, these different facts that have been put into the indictment. So, is it possible for a speedy trial? Yes, but that's a defendant's right. That's not something that we really argue as the government. The government doesn't really argue that. So, accusations are not facts, true, but evidence that's been placed in front of a grand jury is evidence. I mean, it's legal evidence. So whether or not that evidence is credible or not in front of a trial jury, that's to be determined. So we will see how that goes. These are, Patrick, I hear you, but these are some pretty significant charges. Whether there's a finding of guilt, again, we will find out. But let's look first. I want to kind of take everybody through what we're really talking about when we're talking about the charges here. So I've got this page up because what's important are these 4 code sections here. The United States Code Section 371, conspiracy to defraud the United States. Count 2, which is 1512, conspiracy to obstruct an official proceeding. And 1512C2, obstruction of an attempt to obstruct an official proceeding. And I don't think I can emphasize this too much when I say he's being charged with trying to prevent the Electoral College votes from being counted properly. All right, that's what the charge is here. So let's kind of just make sure that we're keeping that clear. There's a lot of evidence that they've set out in front of the grand jury in this indictment, but again, the charges he's looking at here are obstructing justice. So we're obstructing an official proceeding and also attempting to obstruct. So all of this evidence that we're seeing, again, calls to the state, to the fake electors, all of those things that they're putting out for evidence here support this idea that there was this obstruction of an official proceeding, and that proceeding being that counting of electoral votes that they set out on January 6th. So we really need to keep that in mind, that this is the law that's being alleged to have been broken. They're saying he was trying to obstruct this proceeding. So a conspiracy to defraud the United States, again, keep this in mind. The conspiracy element means there's multiple people involved, but this defrauding of the United States, again, is this idea of trying to have these fake electors come in and kind of throw off how the process works for electing a president. So this is a criminal charge. We're not charging him with going out and giving a speech. We're charging this document is charging and saying there was an obstruction of an official proceeding. The official proceeding was the taking up the votes of the Electoral College. All right, so let's just keep that in mind as we go through this. So, yeah, and Jason, you can talk about the Democrats lying and manipulating. That's fine. That's absolutely fine. But, you know, what I'm talking about tonight is this grand jury indictment and, you know, what these charges mean and what the First Amendment means with regards to this. So if you want me to go through what the Democrats have done for that election, tag me on some evidence. I don't have any evidence of that. I have this federal indictment in front of me and code sections and evidence. I don't have anything else that I can focus on. So I understand there's a lot of frustration here, but I'm just looking at the evidence. That's all I'm looking at. I'm looking at court documents, legal code sections, and the evidence. And within the evidence, we've got the rules of evidence here, which, you know, I have taught many times in the past, and the Constitution. So this is just, we're just looking here at the evidence. I'm not picking a side. I'm just going through the facts here. Now, when we're looking at count 4, we've got a conspiracy against rights. And again, this is that under 241. When you look to 18 United States Code 241, that is the chapter of civil rights. Okay, so when you pull that code section up, we've got chapter 13 is civil rights. So conspiracy against rights, which is what is being charged here, has to do with injuring or preventing these kinds of rights that have rights and privileges that have been set out to all Americans. So we're looking to civil rights. That's the section of the code they're claiming was violated because of what occurred on January 6th regarding obstructing the proceeding for the Electoral College votes. Okay, so are you following me on all of that? That's really what we're going to be looking at as we go through this. Yes, obstruction of justice, obstruction of official proceeding. Any official proceeding, anyone could be charged with that. If you are preventing a government body from going forward, you're trying to halt it or interfere with it, you can get charged. That's just, that's a charge. Congress wrote it. That's how it goes. So, this is the law here that we're looking at. So keep that in mind. Again, as we're going through this freedom of speech discussion, as we're going through this evidence here, we're looking for evidence to support that he conspired to obstruct an official proceeding. All right, now part of that involved fraud, which is this section, and the other part of it means that it prevented voting rights from being done properly, or conspiracy to prevent those rights. Okay, so that's how these counts work together. So let's just make sure that we know the law that's being charged here. So, no, you can't filibustering in Congress because the Constitution sets out criminal protections for Congress when you're on the floor. That was written into Article 1 of the Constitution. So that's different. And what about Hillary? Again, I would say I'm talking about this case. I don't have another case. I'm just going through this case here, okay? I have a grand jury indictment in front of me with federal criminal charges here and facts supporting probable cause. That's what I have. I don't have anything on Hillary. If I've missed it, tag me. If I am missing something, again, like I said, just tell me. I will go through it. But I have looked and looked, and I have found nothing. So please, I beg you, just tag me in it, or else, let's kind of move on, because this is what I have. I don't have anything else. So I will be going through this. Let me just grab my handy dandy highlighters to try to explain things also. Oh, thank you. Thank you for the heart. Appreciate that. Okay, so when we are talking about the code sections here, again, we really need to keep in mind the language of the law because that's how our system works. We have laws passed by our legislative bodies and signed into law, and this is the law that's being said that was being violated. So let's really take a look at that because these are the elements that have to be proven beyond a reasonable doubt by the government. So let's look to the code section. Is this in frame for everybody? I just want to make sure I'm here in frame. Just let me know. Yes, okay, thank you, Gail. Appreciate that. Okay, thanks, Muriel. Fantastic. All right, so let's step back again here. We're looking to conspiracy to obstruct an official proceeding, which is United States Code 1512K. So here is Title 18, which is our Crimes and Criminal Procedure Code section. And we've got section 1512, which is tampering with a witness, victim, or an informant. And then we go down to subsection K, which is what's been charged here. And that takes us to this section, okay? So this is the law that he is alleged to have violated. Whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense, the commission of which was the object of the conspiracy. All right, so they're saying here, if you've been charged with a conspiracy under this title, you are going to be facing charges as if you had actually committed the crime you conspired to commit. That's how our inchoate offenses work. I talked a little bit about that last time. We have 3 inchoate offenses. So we have an attempt to commit a crime, we have conspiracy to commit a crime, and we have solicitation. So those are our 3 inchoate offenses. Now, the next charge here, we've got conspiracy, and then here's the obstruction charge. So let's look into that. 1512 subsection C. So we have A, we have B, here is C. And then under subsection C, we have sub 2. Okay? So whoever corruptly otherwise obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title or imprisoned not more than 20 years or both. Okay, so this is the code section he's being charged with. This is interference or obstructs, influences, or impedes any official proceeding. That's what we're looking at, or attempts to do so. All right, so that's the specific code section we're looking at. And then that takes us through to the elements that we need. Okay, so whenever we break apart a crime, when we're trying to prosecute a case, we break it into our elements of intent. We have to have the intent, and we have to have the act. Okay, so mens rea and actus reus. So otherwise obstructs, influences, or impedes any official proceeding or attempts to do so is the act. That's the act itself. Okay. And they'll go into the intent level as well. So there was an intent to do that. And that's where we get our corpus delicti, the body of the crime, or what we need to have for our criminal elements here. All right, so let's move forward then. Now that we have our elements, we've talked about conspiracy. Let's look and see if we have what it takes in order to find probable cause that this section of the code has been violated. All right, so let's just break this apart. We'll just go step by step. All right, so keep our elements in mind. This is what we need. We have obstructed, influenced, or impedes any official proceeding. So we've got, first we need to have an official proceeding or attempts to do so. And then we have to have some kind of obstruction or influence or impediment or an attempt of that. All right. So those are our two pieces we're looking at in the code. Let's take a look then and look at our facts that we've got set out. First of all, we're looking to U.S. Code Section 371, which is conspiracy to commit an offense or to defraud the United States. That's the code section. If two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do any act to affect the object of the conspiracy, we would call that a substantial step. That's the lingo. Each shall be fined under this title or imprisoned not more than 5 years or both. If, however, the offense, the commission of which is the object of the conspiracy, is a misdemeanor only, the punishment for such conspiracy shall not exceed the maximum punishment provided for such misdemeanor. Okay, so there's our conspiracy elements. We've got count one. So they're going to go in and explain the evidence that they have to show that there was a conspiracy to defraud the United States. So let's go through these elements. We have the purpose of the conspiracy. So this will go into the intent element. The purpose of the conspiracy was to overturn the legitimate results of the 2020 presidential election by using knowingly false claims. So here's our intent element. He knew they were false, of election fraud to obstruct, and this is that subsection of the code that we were looking at before, 1215. The federal government function, again, this is another element of that code section by which those results are collected, counted, and certified. All right? So we've got intent here. He knew they were false, and he did it in order to obstruct the federal government function. Again, just to keep that clear for everyone who's following, we have the code section right here. Obstruct, influence, or impedes any official proceeding or attempts to do so. That's what he's charged with. And this is saying there was a conspiracy to defraud because of that. All right, so let's go into our co-conspirators. This is important because with a conspiracy, you need more than one person, which is what the law says. So here we go. The law says 2 or more persons, and they're conspiring, and they're doing a substantial step towards that. So that's 371. So we need to prove that more than 2 people were involved in this. So let's look at the evidence they have for more than 2 people. We've got co-conspirator 1, an attorney who is willing to spread knowingly false claims and pursue strategies that the defendant's 2020 re-election campaign attorneys would not. Co-conspirator 2, an attorney who devised and attempted to implement a strategy to leverage the vice president's ceremonial role overseeing tried to get this a little bit more organized. The certification proceeding. Now, this certification proceeding that they're citing, again, is another element of what they charged. So if you are impeding or altering or getting in the way of this kind of a proceeding, it's obstruction of justice. So they're proceeding to obstruct the certification of the presidential election. Now we have the other element of that offense. All right? Co-conspirator 3, an attorney whose unfounded claims of election fraud the defendant privately acknowledged to others sounded crazy. So now we have knowledge. Knowledge is also a piece of intent. Nonetheless, the defendant embraced and publicly amplified co-conspirator 3's disinformation. All right, so we've got an amplification here. We've got another person involved in false information. Co-conspirator 4, a Justice Department official who worked on civil matters and who, with the defendant, attempted to use the Justice Department, and this attempt counts as an offense. Again, this is another one of our inchoate offenses, but it's actually also listed in the code section if there's an attempt to use the Justice Department to open sham election crime investigations and influence state legislatures with knowingly false claims of election fraud. And again, this is the act. Okay, so we've got attempt, which goes to our intent level. We've also got an act. So those two elements, again, are satisfied underneath the code for probable cause. Co-conspirator 5, an attorney who assisted in devising and attempting to implement a plan to, again, we've got this attempting term, we need that, to implement a plan to submit fraudulent slates of presidential electors. And again, fraudulent slates, this is another element of interference, to obstruct the certification proceeding. And that's specific language set out in 1512. And the last one, co-conspirator 6, a political consultant who helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding. All right, so now we've got an act and an intent with each one of these co-conspirators, and you need 2 or more people in order to satisfy that element under the code. All right, so a conspiracy to commit an offense, and the offense that's being alleged is obstruction of justice, and it's specifically with interfering with a official proceeding or attempting to interfere with it. All right, so now we've got all the elements of the statutes that have been charged. Now, this next piece of the indictment, they're going through and they're explaining what the federal government function is. And the reason that they're doing that is because, again, this is all about the code section. I'm breaking this down like I would break down a criminal case for prosecution here, okay? So, an official proceeding, and we need an official proceeding, and that's based off of an official government function. And let me just pull up that real quick. So that would be under, again, this section of the United States Code. We have at the beginning of this section of the code a setting out of definitions. And for some reason, I have put that somewhere and I cannot find it. But that's what we're looking for here is the definition. That's why we're going to go into the function. So let's talk about the function. The federal government function by which the results of the election for President of the United States are collected, counted, and certified was established through the Constitution and the Electoral Count Act as federal law enacted in 1887. So we've got a federal government function here. The Constitution provides that individuals called electors select the president and that each state determine for itself how to appoint the electors apportioned to it. Through state laws, each of the 50 states and the District of Columbia choose to select their electors based on the popular vote of the state. After Election Day, the ECA required each state to formally determine or ascertain the electors who would represent the state's voters by casting electoral votes on behalf of the candidate who won the popular vote, and required the executive of each state to certify to the federal government the identities of those electors. So I'll pause here because what they're doing is they're explaining the function, and they're explaining that function because we need it as an element. And they're charging that this defendant interrupted, altered, or tried to obstruct this function. And this function was pulling in these electoral votes based off of the popular vote for the states, and then with their executive branch approving that. Okay, so that's why we've got number 9. Manner and means. Now this is the next portion of it that goes into the explanation. of the defendant's conspiracy to impair, obstruct, or defeat the government function. These are all elements needed in order to prove the crime that's been charged. Through dishonesty, fraud, and deceit, including the following manner and means. This is where we'll really start pulling this evidence apart and taking a look at it, okay? So, the defendant and co-conspirators used knowingly false claims, here's our intent element, of election fraud to get state legislatures and election officials to subvert the legitimate election results. Let's stop there. We already have now the act that is discussed within the code section, right? If we are otherwise obstructing, influencing, or impeding any official proceeding or attempting to do so. And then we just had the prior section that said our electors are chosen in a certain manner in our states. And now here we have a piece of evidence that's saying they used knowingly false claims in order to impede the election results in the states. Okay, are you following me with that? So that's why we have this element here. So this evidence is proving that piece of the code. And change electoral votes for the defendant's opponent, Joseph R. Biden Jr., 2 electoral votes for the defendant. Again, this is another impeding of an official function. That is on the pretext of baseless fraud claims. Baseless fraud claims. So they're going to be showing we've got fraud claims and that those claims are baseless then. The defendant pushed officials in certain states, again, involving this official function, government function, in certain states to ignore the popular vote, which again is another element of that governmental function that's being obstructed, disenfranchise millions of voters. This is another piece. Dismiss legitimate electors, obstruction, and ultimately cause the ascertainment of and voting by illegitimate electors in favor of the defendant. And again, illegitimate electors is interference. All right, so every single sentence in here is another piece of evidence showing that there was a violation of this section of the code. So interference with this official government working. And that being the counting of the electoral votes. So this is specific to how January 6th went down. Now, because everything ended on January 6th, everything was planned according to this indictment in order to lead to that January 6th moment. There's no evidence showing him doing any of this. Well, Harley, I just showed you the evidence right here. They used knowingly false claims of election fraud. And the rest of the indictment, they'll go into each state individually and explain what they did. So, that's not much clearer than that. I guess that's not evidence. Well, Christy, if it's presented in court to a grand jury, it's evidence. If it's credible evidence or not, that's for a trial jury to decide. But it is actually evidence. I mean, we put that in court. That's what's called evidence. Right. All right. So I'm just keeping one eye here on the comments, just so that I can kind of help out. He has to go to court. Yes. Yes, this is not proven beyond a reasonable doubt. This is a finding of probable cause. This is the evidence to show we've violated this code section. So let's get into the next piece of evidence submitted to a grand jury, a federal grand jury. All right, so we have to be governed by the rules of evidence in federal courts. Got to follow those rules. And under the federal rules of evidence, you have to have relevant evidence, or else it's not admissible. So let me just, clear that up real quick. Here you go. Here's the rule for evidence in federal court. This is the rule. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And subsection B the fact is of consequence in determining the action. So that's the federal rule of evidence. I mean, that's the rule. So if the evidence does not meet Rule 401, it's not admissible. You can't use it in court. So, I mean, that's the rule. That's just a rule. I didn't write the rule. I'm just reading the rule to you. And that's available online too. So let's go into this next piece here and take a look at what evidence we've got. The defendant and co-conspirators organized fraudulent slates of electors. Now, this phrase right here, again, this is an act. We need that act plus the intent in 7 targeted states: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, attempting to mimic. So again, we have this intent, this attempt word, to mimic the procedures that the legitimate electors, so now we have fraudulent electors and legitimate electors, were supposed to follow under the Constitution and other federal and state laws. Now we're pulling in what the rules were to make them legitimate versus the fraudulent ones that are not in compliance with the Constitution and the federal and state law. This included causing the fraudulent electors to meet on the day appointed. Welcome, VC. Welcome. Thank you for joining me tonight. I popped on a little early because I feel like we're going to need a little extra time tonight. So this included causing the fraudulent electors to meet on the day appointed by federal law on which legitimate electors were to gather. Right? So again, we have this term. We've got fraudulent electors versus legitimate electors were to gather and cast their votes. Cast fraudulent votes. So here is another action that is fraudulent for the defendant, and signed certificates falsely representing. Again, we have an official act here that they were legitimate electors. Some fraudulent electors were tricked into participating based on the understanding that their votes would be used only if the defendant succeeded in outcome determinative lawsuits within their state. So I want to just take a moment here to note this word tricked goes to the intent of the electors that were involved. So the intent of the fraudulent electors. This is an E. The fraudulent electors there. Okay, so this is, again, another element of intent, which the defendant never did. So he had made a promise here, so he had tricked them, and what he said he would do, he didn't do. So the defendant and co-conspirators then caused these fraudulent electors to transmit their false certificates. So this, again, is another act as part of what we need in any criminal case. False certifications to the vice president and other government officials to be counted at the certification proceeding on January 6th. Now, it's this proceeding that is the official government function that's being messed with, all right? So again, I know you're probably going to get tired of me showing you this, but he's charged with obstructing, influencing, or impeding an official proceeding or attempting to do so. That's the charge. And here they're saying they're going to give these false certificates to the vice president and other government officials to be counted at the certification proceeding, which is that official proceeding that they're talking about in the federal code. Okay? So that's the next piece of evidence that they're looking at for probable cause. Well, electors, great question. Electors are chosen by the state, and they are the ones that are speaking on behalf of their state. It's a very old school technique. It didn't work when they wrote the Constitution. It didn't work when they tried to fix it in the 12th Amendment. But, you know, it's kind of what we got right now. It's a bit of a mess. But, you know, does anyone remember, and just for a second, before I move on here to see, and don't worry, I'm just going to be going through the evidence tonight. I won't be reading the whole indictment, but does anybody remember back in 2020 or 2016, sorry, it was a long time ago. Does anyone remember when those popular votes were coming in and they were not coming in a way that set out the number of electors correctly for Hillary Clinton. Does anyone remember that? And so there was some discuss about, well, let's have the electors that were already chosen vote for her instead of for Trump. And some electors had refused to cast their votes for Trump for the Electoral College. Does anyone remember that? Because there was a lot of talk about that during 2016, but there was no fruition, but there was some debate. So this is something that was kind of on the table. Yes, you do. Okay. This was something that had been put up and out into this idea of trying to move electors to a different candidate to cast their votes differently. Now, of course, at the time, the constitutional scholars came in and said, that's just, you can't do that. It's not possible. So this is really kind of a, what would have happened if something like that had gone down in 2016. So it's interesting, I think, academically, to see, there was a lot of talk about that, but then when you try to put in fake electors and you try to mess with that electoral college process, then, you're obstructing this proceeding. So it's a very interesting, I think. Back then we were all surprised. Yes, we really were, Blue Jean. We were all very surprised. I mean, I wasn't particularly surprised only because historically that's how I had expected a Republican to come in as president based off of our history. But, I think a lot of people, I think it was very... Yes, the system caught it, Hawaiian. Exactly. So that's how it went down. But I just think it's fascinating because here we are again. We've got a different set of facts. Before we just had, electors saying, I'm not going to cast my vote. But now we've got slates of fake electors, of people coming in and casting votes that are illegitimate. So it's very interesting. Yes, we have electoral problems. We have electoral college problems, absolutely, but we can't seem to get together enough as a country in order to fix it because we would need a constitutional amendment. I think that'll happen in time, but we will see. All right, so let's go through this next set of evidence. Again, we have our code section here. This is the code that is alleged to have been violated regarding the official proceeding, which is the counting of the electoral votes and putting those through. So let's go in here. The defendant and co-conspirators attempted to use the power and authority of the Justice Department to conduct sham election crime investigations and to send a letter to the targeted states. And again, this is another part of the act where they're getting involved with the official proceeding to the targeted states that falsely claimed. Again, this is intent that the Justice Department had identified significant concerns that may have impacted the election outcome. Again, this is our official proceeding. That sought to advance the defendant's fraudulent elector plan by using the Justice Department's authority to falsely present the fraudulent electors as a valid alternative. So again, we're going into more details of how this official proceeding was being obstructed to the legitimate electors, and that urged on behalf of the Justice Department the targeted state legislatures to convene to create the opportunity to choose the fraudulent electors. So they're setting up a fraudulent road for people to go down, and this setting up of this action here, again, is we're impeding that official proceeding. Okay, so that's another set of, yes, I've printed it out a couple times, actually. This will be my First Amendment discussion printout. So, yes, this is the evidence again. So this is the Justice Department evidence where they're trying to pull in an official support for fraudulent practice in order to hinder that official proceeding. Okay? So that's for C. So next we will go into D. The defendant and co-conspirators attempted to enlist the vice president to use his ceremonial role. Again, the ceremonial role is talking about a proceeding at the January 6th certification proceeding to fraudulently alter the election results. Again, this fraudulent altering of election results is the proceeding that he's being charged with interfering with. First, using knowingly false claims. There's our intent element. False claims of election fraud. The defendant and co-conspirators attempted to convince the vice president to use the defendant's fraudulent electors. Reject legitimate electoral votes. So here's one thing that they're asking him to do. They're also asking him to reject legitimate electoral votes. Or 3, here's the third act, send legitimate electoral votes to the state legislatures for reviewing rather than counting them. So we here have 3 separate actions that they are asking the vice president to do to interfere with the proceeding of the Electoral College, the electors' votes. Okay? So, three examples. When that failed on the morning of January 6th, again, they're taking us to the date of the crime. All right, this is the date the crime occurred because that's when the proceeding occurred, was January 6th. So this is the date of the crime. The defendant and co-conspirators repeated knowingly false claims of election fraud to gathered supporters. Now we're getting into this idea of incitement, which is going to take this out from underneath the safety of the First Amendment. All right, so this is kind of our first step. I'll further get into how the First Amendment does not protect this kind of speech, but this is that first piece of evidence showing we've got a group of people gathered. Falsely told them that the vice president had the authority to and might alter the election results. So we've got one false claim said to the people in order to potentially incite, and then directed them to the Capitol. So this is that imminent lawless action that's required under the Brandenburg test. This is meaning right here, this statement is what keeps this out of the land of First Amendment protections. All right. So if we've got an imminent lawless action that's being incited that is likely to occur, we do not have the protection of the First Amendment. We don't. Yes, Cookie's mom. It does. It really does. And that's really why I'm here tonight, is to explain this. This is such a huge thing that I think a lot of people don't understand. And it could very well be because we're just not clear about teaching it. But this is so important for everyone to understand. The First Amendment can be regulated. It absolutely can be regulated, but it's very carefully looked at. Our regulations are very, very careful, okay? We have a test out of a case, and the case itself was a unanimous decision out of the Warren Court, and it set out a 2-part test, and I will get into that. Right. And to add with that, you need to have some kind of imminent lawless action. Now, I'm going to just take this moment again because I think it's just so important. Okay, here is the case. This is the case. All right, this is the key to everything under the First Amendment, is Brandenburg versus Ohio, and it set out the imminent lawless test. Before this case, we had the Whitney versus California, we had Schenck, we had all kinds of cases that said if the state passes a criminal syndicalism law, so if there's a law that says you cannot tell people to be violent in order to go forward on your political ideations or to rebel against the government, those statutes were okay until this case. In the Brandenburg versus Ohio case, they set out a statute that said you cannot advocate violence of crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. This is the Ohio statute. And for voluntarily assembling with any society group or assemblage of persons formed to teach or advocate the doctrines of criminal syndicalism. So the Ohio statute said you may not gather to learn and advocate violence or criminal actions to accomplish a political reform. You can't do that. the Supreme Court said the Ohio statute was unconstitutional. All right? It's unconstitutional. They said their statute was bad because you cannot regulate First Amendment speech because of that. Now, before we get too thrown off and say, yay, good for freedom of speech, what they did then was they set out a test. And they said, because Ohio statute is not specific enough, we're going to give you a test to use. So whenever there is a law that restricts this kind of speech, the law has to follow certain principles, all right? And they're citing here all the different cases that have said in the past where you can't advocate for violence. And they're saying in this case, we need to have freedom of speech be allowed. Here's the test, okay? Freedoms of speech and the press do not permit a state to forbid advocacy of the use of force or of law violations. So they're not allowed to have a law that are forbidding this kind of action except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. That is the test. So if there is speech being used to violently advocate the overthrow or of going forward violently in order to push your belief or your government reform, if it's directing or inciting or producing an imminent lawless action and is likely to incite that, it is not protected by the First Amendment. Okay? Exactly. That's exactly it. So the Brandenburg test, if you apply it to this situation, all right? So let's talk about the speech on January 6th. Let's just talk about that. If you look at the words that were used, which the indictment goes into, under every single paragraph, they say these words were used on January 6th. These words were used in January 6th for every state and for every claim. So they outline his speech in this indictment. They're doing that to show that his speech does not qualify under the Brandenburg test because they are inciting or producing imminent lawless action. What is the imminent lawless action? Keeping the electoral votes, the electors, from being cast and for the ceremony to be going. They try to prevent what was supposed to be done by the vice president in the Senate that day, and they did for several hours, and they show that in the indictment. So this action was likely and did produce the action, so it is not covered or protected by the First Amendment. That is the test. So that is why the First Amendment here is not going to protect the language that was used that day. Now, I will get in more into more pieces of the evidence supporting the conspiracy, supporting the probable cause for the charge. But when it comes to the First Amendment, we are talking about that Brandenburg test. Okay? That's what we're talking about. So you can look it up. You can look at all of those pieces, and just to take it one step further. Okay, let's just, for the sake of argument, say, hey, that Brandenburg test was a long time ago, right? That was too long ago. Okay, Counterman versus Colorado. This was decided June 27th, like a few weeks ago, all right? True threats and recklessness are not covered by the First Amendment. If you look at this case that was decided just a few weeks ago, they are going to be in here citing the cases stating for Brandenburg and for any kind of those clear and present danger questions, it's not protected by the First Amendment. Now, let me give you an exact citation, all right? Just to clarify everything, just to make sure everybody is with me on that, okay? And here it is, right here, okay? Brandenburg versus Ohio. This is the case I'm telling you about. One is incitement, statements directed at producing imminent lawless action and likely to do so. All right? And she's listing these out as restrictions on the First Amendment, not protected by the First Amendment. So, I get it. Brandenburg's an old case, but Counterman was decided like 6 weeks ago. All right. So the First Amendment doctrine of imminent lawless action just is what it is. So that's where that goes if you are wondering about the First Amendment. So we'll keep talking about it. We'll keep talking about it. Now, let's go into the next piece of evidence here, because I really do want to kind of go through this a little piece at a time. Brandenburg is still good law, but find cases that show whether it meets that standard. Well, Russ, I've got, how many cases do you want? What cases do you want me to pull? I mean, I got my whole room's filled with cases. What cases do you want? I'm just giving the highlights here because I'm trying to kind of explain things. You do not have a legal studies degree. That's true. You're right. I have a doctorate of jurisprudence. I do not have a legal studies degree. Okay, so I just get so excited talking about the First Amendment. I get so excited about it. I do. I find it very interesting and exciting to talk about with people because it's so misunderstood. So that's why I'm happy to come on here and kind of talk about this because it's fascinating. It's a fascinating area of the law. All right, let's go into this last piece of evidence that we have here. After it became public on the afternoon of January 6th that the vice president would not fraudulently alter the election results, a large and angry crowd, all right, so again, we're going to that imminent lawless activity, including many individuals whom the defendant had deceived into believing the vice president could and might change the election results, violently attacked, all right, again, the Capitol and halted the proceeding. This is that direct language that goes to the issue in 1215, all right, which is that interference with that official proceeding. As violence ensued, the defendant and co-conspirators exploited the disruption by redoubling their efforts to levy false claims of election fraud and convince members of Congress to further delay the certification based on those claims. And here again, we've got more acts to support this specific issue that we've got. I've read the speech, Sleepy Sumo. I think everyone could read that speech. I think that would be very helpful for everyone to understand. Absolutely. Absolutely. So, again, just to remind everybody here, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. All right? So that's the section of the code. Now let's keep moving on. We've got lots of great evidence to go through here. Oh yes, no bigotry. No. We don't do that here. We just don't do that here. This is just for good, clean learning and debate and discussion, and that's fine. But blatantly false information or bigotry, those kinds of things, we just don't do that here. And I've got amazing moderators helping out. So thank you so much. Right. It does help to have a law degree. I found that to be very helpful in being able to practice law and teach it. So, all right, here we go. The defendant's knowledge of the falsity of his election fraud claims. Now, the reason that they've put this in here is because of that intent element. Remember, we need an intent and we need an act in order to go forward with our crime. So we've got, they're trying to prove here that he had knowledge that these things were false. He knew they were false and he went forward anyway. So the defendant and his co-conspirators and their agents made knowingly false claims that there had been outcome determinative fraud in 2020 presidential elections. These prolific lies about the election fraud included dozens of specific claims that there had been substantial fraud in certain states. And then they go through and give examples. Now, I will go ahead and go through this evidence also because, again, evidence of probable cause, not proof beyond a reasonable doubt. Oh, I assure you, I do have a law degree. I do assure you that it's going down, and I've got the student loans to prove it. So, I do, and the nightmares, finals. Whoo, goodness. So we will go into this evidence here, but they're going to again put out. They're going to the actions that were done by Donald Trump on January 6th. The speech he gave, along with the information that he gave. So this conspiracy all led up to that date and time in those actions, which led to the charges. Yeah, the student loans, goodness. Whew. I'm still looking at Biden versus Nebraska, that Supreme Court case, and I'm just like, that's a shame. But that's how it goes. So these claims were false, and the defendant knew that they were false. In fact, the defendant was notified repeatedly that his claims were untrue, often by people on whom he relied for candid advice on important matters, and who were best positioned to know the facts, and that he deliberately disregarded the truth. Again, we've got this element of intent. So let's go through this evidence that was put out in front of the grand jury. Yes, anytime we want to talk about freedom of speech, everyone who has heard my spiel on it, and I will continue to give lots of spiels on it, now you know, and you can spread that knowledge. Take it with you. Spread the knowledge. That's really important. So, yes. All right, so let's go through this first piece here. The defendant's vice president, who personally stood to gain by remaining in office as part of the defendant's ticket, and whom the defendant asked to study fraud allegations, told the defendant, here's the evidence, that he had seen no evidence of outcome determinative fraud. All right, so here's our first piece of evidence. We've got a statement from thank you. We have a statement from the vice president, all right? So this statement is saying, he told the defendant there was no evidence. So now we're going to say, hey, well, how does the vice president get to say something to the defendant and we get to use that in court as evidence, right? That's what everyone's question is. So let's take a look and say, okay, well, how does that get to come in? Let's look to the rules of evidence. And when we look to evidence, we have a couple things we have to look at. First, we have to look to witness statements. So here's our witness section under Article 6, the need for personal knowledge. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to a witness's expert testimony under Rule 703, and 703 governs our experts. So this is the rule that allows for a witness to testify to personal knowledge. If we look at this piece of evidence, the vice president made this comment and told the defendant that there was no evidence of this fraud. And so how does that statement go into court? Well, you would have to call in the vice president to testify. Now, when he goes in to testify, he can testify because he has personal knowledge because he was there when he had this conversation. And then you say, well, it's hearsay. Hearsay is not allowed. So let's look quick, and I'm not going to spend the night talking about hearsay because that's a full lecture. But we've got exceptions against the rule of hearsay. So when we have a hearsay statement, we have a statement, a person's oral assertion, if the person intended it as an assertion by the declarant, outside of court, being used in this court to prove the truth of the matter asserted. We're trying to prove the defendant knew that the fraud allegations were false because the vice president told him there was no evidence. So now the defendant knows there's no evidence because the vice president told him. All right, are you following that analysis? Now here we go for when we're looking to see, well, what kind of exception for hearsay can come in. And in this particular situation, I would say, let's look through here. We've got all these different exceptions here. made by the party's agent or employee on the matter within the scope of that relationship while it existed. Okay, so we've got this piece here, party's agent or employee is not necessarily one of the pieces that you would use, but present sense impression could be a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. So I would use that. Go for it. As long as it's a present sense impression. I wouldn't necessarily say it was an excited utterance, but to give you an example, we've got, 27 exceptions that we could fit that under. That's a great question. Did the vice president say there is no evidence or sees no evidence? Fabulous question. So we go here and we say told the defendant that he had seen no evidence of outcome determinative fraud. So the vice president, this is the vice president, had seen no evidence. Now keep in mind, in this section of this indictment, they're trying to say to the vice president, there's been fraud, so we need you to become a part of this. And so this is the evidence showing his reaction to that. The vice president said, I've seen no evidence of this kind of fraud. He can testify to that in court. He would need to be called in. Well, and truth seeker, again, that's a fantastic question without an investigation. And see, a lot of information is missing here. We don't have all of the details of it, but the vice president then would need to go into, well, how do you know that? How have you not seen any evidence? Has anyone spoken to you about it? Have you seen any reports? What's going on? Those kinds of questions would absolutely need to be asked. And we're going to kind of address those as we further go on through the different pieces of the indictment here. It has been a week. It has been. Dagwood, I'm not sure what was rigged. I'm not sure what you mean by it was rigged. The grand jury. Yeah, the grand jury. Exactly. So evidence needs to be tangible. There's different standards of evidence that we use for a grand jury versus a trial jury, but that's, as long as the evidence is valid, it's allowed to come in. No evidence, no participation. That's true, it's not. So I think if we didn't have anything else, if we only had this, I'm not sure that would show probable cause. I'm not sure it would. Let's look at what else we've got together, because we're going to look to the totality. The senior leaders of the Justice Department appointed by the defendant and responsible for investigating credible allegations of election crimes. All right, so now we've got leaders who have been investigating, told the defendant on multiple occasions that various allegations of fraud were unsupported. So now we've got senior leaders in the Justice Department whose job it is to investigate credible allegations are saying there is no fraud. So we've got the vice president now. We've got senior leaders in the Department of Justice. All right, so now we've got two, a little to the left. Oh, sure, there you go. Let me know if that's better. It takes a minute here. Is that better? Hopefully. Yes. Thank you. Thank you for telling me. Okay, good. Thanks for telling me. I appreciate that. I'm trying to keep one eye here on the comments so I can answer questions and so on. So, because again, this is just a discussion. We're just kind of talking here. Now, right, so we've got the vice president's statement, and people are saying, we've got some questions. He's just saying he's seen no evidence. What exactly does that mean? Valid questions. I think those are good questions to ask. Now we've got B, the senior leaders of the Department of Justice are saying there's no fraud that's supported. So, again, in the legal field, we've got the Department of Justice doesn't have the credibility questions that I think a lot of the public has, but whatever, we're going to have this in front of a jury, which are people, just regular citizens. So next, let's go to C, the Director of National Intelligence. So now we've got another character here. We've got number 3, the defendant's principal advisor on intelligence matters related to national security disabused the defendant of the notion that the intelligence community's findings regarding foreign interference would change the outcome of the election. All right, so now we've got the director saying there's no finding regarding foreign interference. All right, so this is foreign interference. All right, so that's specific to that category that would change the outcome of the election. The Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, so CISA, let's see what they have to say, whose existence the defendant signed into law. So I think they're trying to say, hey, you created this agency to protect the nation's cybersecurity infrastructure from attack. So they're saying the defendant must have faith because he's the one that created it. Joined an official multi-agency statement. So now we've got lots of different agencies involved, that there was no evidence any voting systems had been compromised. So I think now we're really getting into more of the finite details here. So no evidence of any voting system that has been compromised and that declared the 2020 election, quote, the most secure in the history of America. All right. So I think I would say out of these four, A, B, C, and D, I would say D is probably the most persuasive. If you would, what do you guys think? We got the vice president here. That's questionable. The Department of Justice is saying, hey, we don't have anything. The Director for National Intelligence is saying there's nothing involving foreign interference. Now we've got the CISA agency, and they're saying us, along with multiple other agencies, are showing it's the most secure in history. So to me, letter D seems like the strongest when it comes to showing that it was made known to the defendant that he knew that these claims he was making was untrue. Right. Oh, Santiago, no. You can't handle the truth. It did. Yeah, Congress shut down for 6 hours. You think B is the most important? That's an excellent point. I mean, it is the Department of Justice. In a court of law, the Department of Justice, again, certainly has a lot of credibility. But I think, too, I like the specificity, honestly, just as an academic point of view. I like the specificity of the CISA, of CISA, and explaining that we've got multiple agencies going into it. All right, so now we've got 4 separate places saying to the defendant, this is not true. Let's go into E, senior White House attorneys. So now we've got a set of the White House attorneys, so his own attorneys here, selected by the defendant to provide him with candid advice. And so he knows that they're giving him legal advice. That's their role. Informed the defendant that there was no evidence of outcome determinative election fraud, and told him that his presidency would end on Inauguration Day in 2021. So now we've got the senior White House attorneys involved. And they are telling him, they are legally advising him that there was no evidence. Oh, go back up. Did I stop? Days later, after the CISA director, whom the defense... Oh, you're right. I missed that. How could I miss that point? Let's go back up there. Let's go back to CISA. Days later, after the CISA director, whom the defendant had appointed, announced publicly that the election security experts were in agreement that the claims of computer-based election fraud were unsubstantiated, then the defendant fired him. So I think this again is another huge point for D. Thank you for pointing that out again. Fired. Yeah, that's pretty significant. That's not really how the real world works. Yeah, that is huge. You're right. All right, so we've got here are our sets. Let's make sure we don't have an F. Oh, we do. We have F, G, and H. So we still have more to come. So we've got the Vice President's statements, Department of Justice, the Director for National Intelligence, CISA, which got fired. That dude got fired. And then the senior White House attorneys are all telling him that the fraud is incorrect or unsubstantiated. So let's go into these last pieces of evidence here. Let me make sure I'm in frame well enough. So, right. So, senior staffers on the defendant's 2020 re-election campaign Okay, so we've got senior staffers. That's our next group of people whose sole mission was the defendant's reelection. So we can see their intent here. Told the defendant on November 7th, so we've got a specific date, that he had only a 5 to 10% chance of prevailing in the election, and that the success was contingent on the defendant winning ongoing vote counts or litigation in Arizona, Georgia, and Wisconsin. Within a week of that assessment, the defendant lost in Arizona, meaning he had lost the election. All right, so they're trying to put together this idea that his staffers said, hey, if you don't win one of these 3 states, you're done. And ultimately, he did not. So the inference then is that he should have been done with that. So senior staffers here. Now we've got state legislatures and officials, many of whom were the defendant's political allies and had voted for him and wanted him to be reelected. Again, this goes to intent. Repeatedly informed the defendant that his claims of fraud in their states were unsubstantiated or false, and resisted his pressure to act based upon them. So now we've got state officials involved. We've got batches of state officials, and again, they could all be called in to testify. Did you tell the defendant this was false? Yes, we did. Well, why don't you take me through that situation? So, and then they can do that. Move the paper again. Did I see that again? Move the paper. Let's see. Is it too far down? There we go. Yeah, I'm just reading the document. I'm just going through and clarifying it. No, you don't have to go by the advisors. Absolutely not. This is showing, did he know that the information was false? Did he know? And so this is the evidence that they took to the grand jury to say, yeah, he knew. All these people told him in all these different situations. So he knew. So this goes to the intent of it. Right. That's what they're proving. They're going through to intent. So let's go to this last piece. State and federal courts. That's a pretty big piece when you've got courts involved. The neutral arbiters responsible for ensuring the fair and even-handed administration of election laws rejected every outcome-determinative post-election lawsuit filed by the defendant, his co-conspirators, and allies, providing the defendant real-time notice that his allegations were meritless. So this, again, we've got lawsuits now where the courts have come in and said there's no basis for these allegations. They're meritless. So now the courts have told him. So that's a lot. That's a lot. We've got a lot of different people here telling him. So if there was a way, and again, I'm just thinking, I'm like, if there was a way for him to come in and say, I didn't know. I thought I was saying true things. What they're saying is based off of all of these different people, and all of these people would be called in to testify. They all, told him that it was, and if nothing else, he had lawsuits. And then he had courts telling him. So there we go. That's the evidence there. Now, let's move on just a little bit further. Again, that's quite a bit. And, maybe not all of it is the best, or maybe it is. It's hard to tell. There are at least 50. Yes. Oh, absolutely. Absolutely. It's really, this idea that he didn't know, if I was his defense counsel, I would just hit that so hard. I would be like, you know what? He had no idea. He just, wasn't paying attention. Too much was going on. He had a lot going on. He had to figure things out. He was worried. He really didn't know. But then what they're doing is they're listing, well, these guys told him, and these guys told him, and the courts told him, and all of these people over and over and over again, they all told him. So at what point do you say, how did he not know? I mean, I'm just asking questions. I'm asking questions. So, I think those are, hurdles that the defense counsel will have to come over. So as it's hearsay is protected by attorney-client privilege. Yes, hearsay's attorney-client privilege is tricky because if there's any kind of illegal actions going on, can't prove what a person knows. Well, you can because you call them to testify and you ask them what they know. That's how you prove it. He didn't believe them. That's legitimate. That would be a legitimate thing. He could say, all these people, the courts, the state officials, the staffers, the Department of Justice, the CISA guy that I fired, the vice president, the White House attorneys, all of them were lying to me. I did not believe them. Absolutely could say that. Absolutely. Absolutely. Yeah, there was one that he fired. So, but yeah, and again, if you look at it from the defense side, because that's how I'm looking at it. I'm looking at it from both sides. What does the government need to prove? What does the defense counsel need to do in order to put on a good defense for him? So defense counsel is going to want to take that intent out. So excellent points for that. Until they believe it's their money. Oh my goodness, that is a fabulous point. That is a fabulous point. Well, it's not mine. It's not mine, or it is mine. You can't steal your own money. So what if it's in a bank? It's still my money. Oh my gosh. Yes, to change results. Yes, exactly. Spooky Mulder. That's right. And none of that has... the charge is that he was obstructing an official proceeding on January 6th. So again, this is all just supporting the intent behind it. Oh, thank you. This is supporting that intent. So, we're not trying to prove he really knew that it was fraudulent. The point was, even if he didn't, let's say hypothetically he believes, let's play around with this for a little bit. Let's say hypothetically he truly believed that all of that was fraudulent. So he is still obstructing, influencing, or impeding an official proceeding or attempting to do so. Even if he believed it was fraudulent, he could have gone to the courts. He could have filed more claims. There were all kinds of legal things he could have done if he really felt everything was done improperly, illegal. So the election was illegal. You have to go through the proper legal channels. But this code section states here we're obstructing, influencing, or impeding an official proceeding. That's it. That's what we're looking for. So, yes, and he said peaceful protest, and those buzzwords can be used, absolutely. And it'll be up to the jury to decide what's credible. Yes, it is. It is, Beat. It is awesome. There are lots and lots of smart people. Thank you, smart people, for joining me. All right, thank you so much. Yes, he did. He did say that, and those could be definitely seen as inciting words. All right, the defendant widely disseminated his false claims on election fraud for months, despite the fact that he knew, and again, they're relying on all these other parties telling him. So he knew, whether he believed them or not, he knew how all of these other people thought about it, and in many cases had been informed directly and had been told that they were not true. The defendant's knowingly false statements were integral to his criminal plans to defeat the federal government function, obstruct the certification, and interfere with others' rights to vote and have their votes counted. And this goes into later charges. So he knew, he gave false statements. They were integral to his plan in order to not have votes counted. Then he made those knowingly false claims throughout the post-election time period, including those below that he made immediately before the attack on the Capitol on January 6th. Now, again, this is going to go for supporting of what his intent was on the 6th. Oh, yes, absolutely. I'm hoping this is helpful. I'm hoping this is of some assistance here for people to kind of understand how the legal system works. Only the reason they pulled this was for 2024. Now, Katrina, you can say that, but again, this is a federal grand jury indictment. So you're going to have to take that to the next level and say somehow a federal grand jury got pulled in false evidence was presented to them, and they came back charging a president of the United States with like 4 major felonies. I mean, just for fun. I mean, I don't know. That's a lot. That's a lot. Like, that takes a lot of work to put that kind of thing together. They're paid. How much would it take? I know I'm going off for a minute on a tangent, but how much would it take for you, a citizen of the United States of America, to be pulled in for a grand jury and allow false evidence to be presented to you, and you take an oath where you can go to prison for 20 years, and you come forward with charges that could put you in prison for 20 years if you're lying about it? So I think there's a lot of, issues there. I mean, how much would that cost? That would cost a lot. And grand juries are not paid. I mean, they're paid like what, $15 a day to be there? I don't think they're even paid gas. They might be paid mileage depending on your jurisdiction. They're paid pennies. You think they want to be there? No way. They don't want to be there. This sucks for them too. All jurors. I have yet to meet a juror that was like, woohoo, I'm so glad I got stuck on a jury. That's fabulous. No, they don't. That's not really how that wants to work. $10? Did someone say $10? Yeah, I'm wondering. Oh yeah, $10 a day. Yep. Mm-hmm. Yeah, so money talks, but that'd have to be a lot of money to make you, lie to a court. I mean, that's like a federal court too, not even oh, you love jury duty? Good for you. Good for you. I wish you were in my jurisdiction. Yes. Yes, there will be recaps. I am posting I'm posting most of my streams. It takes a few hours for me to get them back up, but they will be up. So yeah, not even lunch money. Yeah. I mean, it'd take a lot. That's a pretty significant, huge perjury situation. Oh, am I a lousy attorney? Maybe. My reviews haven't been bad yet, but you never know. All right. So, right. I mean, there's a lot of questions. And that's what we're here for. We're definitely here for, to look through this. So, oh, thank you. All right. Well, let's move on now to this next piece of evidence that they set out. So we've got knowingly false claims, and this is what's going on before the attack on the 6th. And again, I'm just going through the evidence. I won't be reading through the entire indictment, but we will. Oh, thank you. Thank you, Bianca. I appreciate that. We'll go through this. So the defendant insinuated that more than 10,000 dead voters had voted in Georgia. Just 4 days earlier, Georgia's Secretary of State had explained to the defendant that this was false. So now he made a statement, all right, that the Georgia Secretary of State, I'm not sure, that's a pretty significant person explaining that it was false. I mean, this is the person in charge of that. So he, yes, we are happy you're here. So Secretary of State said, hey, that's false. All right. So there's the evidence. Just call the Secretary of State in. Did you explain to the defendant? Yes, I did. What'd you say? I said it was false. And then take me through that. That's the kind of questions that she would be asking. So the defendant asserted there'd been 205,000 more votes than voters in Pennsylvania. The defendant's acting attorney general, so his own acting attorney general and acting deputy attorney general, had explained to him that this was false. So now we call them up to the stand and we say, hey, were there 205,000 more votes than voters in Pennsylvania? No. Did you explain that to the defendant? Yes, I did. And again, that's if the judge allows, this testimony about this election even to come in, because this information, may not even be relevant other than to say, what words did he use to incite the crowd that day in order to disrupt the proceeding? So again, I'm just guessing here. We're not having a trial about whether or not 2020 was fraudulent. That's not what this trial is about. This trial is about impeding the proceeding of the government that day. So that's what this is about. So the defendant said that there had been a suspicious vote dump in Detroit, Michigan. defendant's attorney general, again, we just call him to testify, had explained to the defendant that this was false. And the defendant's allies in the Michigan state legislature, the Speaker of the House, another witness, and Majority Leader of the Senate, another leader, had publicly announced that there was no evidence of substantial fraud in the state. Okay. The defendant claimed that there had been tens of thousands of double votes and other fraud in Nevada. The Nevada Secretary of State had previously rebutted the defendant's fraud claims by publicly posting, so now we actually have a posted statement here, document explaining that Nevada judges had reviewed and rejected them, and the Nevada Supreme Court had rendered a decision denying such claims. So now we've got a court decision that said that there was no fraud. So that's pretty significant. How would they prove that? Well, we would pull in the Nevada Secretary of State. So what did you do regarding fraud claims for voter fraud in your state? Well, we wrote this document. And what was in the document? Well, blah, 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 blah. And then you would call in the clerk of court for the Nevada court, and they would say, hey, did you have a judgment that was done on such and such? Yes. And what was the finding of the court? The finding of the court was there were no fraud claims. So you would pull your witnesses in, put them on the stand, and any documents that they had, that's when you would introduce those pieces of evidence. Next, the defendant said that more than 30,000 non-citizens had voted in Arizona. The defendant's own campaign manager, so there's another witness, had explained to him that such claims were false, and the Speaker of the Arizona House of Representatives, who had supported the defendant in the election, had issued a public statement. That public statement can come in also, you would call that Speaker of the House to testify that there was no evidence of substantial fraud in Arizona. The defendant, oh my goodness, thank you. The defendant asserted that voting machines in various contested states had switched votes from the defendant to Biden. The defendant's attorney general, acting attorney general, and acting deputy attorney general all had explained to him that this was false, and numerous recounts and audits had confirmed the accuracy of the voting machines. So there we've got two people who can testify along with whoever's in charge of the voting machines. So whoever from the company can come in and testify and say, hey, did you have your voting machines there? Yes, we did. And were they working that day? Yes, they were. How are they working? Explain the process, blah, blah, blah. And then were they working according to that process that day? Yes, they were. Okay. So did you find any showing of fraud? No, we did not. Were the machines okay? They were. So that's the kind of testimony you're going to hear when you call someone in regarding the voting machines. And for these guys here, it's going to be, hey, were you, what position did you hold? I held this position. Did the defendant talk to you about the voting machines? Yes, he did. Did he have concerns about fraud? Yes, he did. What did you say to him? I told him the machines were fine. There was no fraud. That's the kind of testimony. So, voting machines are thoroughly automated. Oh, you were involved. Oh, good for you. Thank you. Thank you for your hard work. Anyone that works the polls or voting machines during our elections, that's, they're the ones that make it happen. So thank you. Thank you for your service. So these are the other pieces of evidence, and all of these people can be pulled in and asked to testify. Did you talk to the defendant? Yes, I did. Any statements that the defendant made to them, again, I'm going to pull out my handy dandy book here. Statements that are non-hearsay. A statement that meets the following is not hearsay. A declarant witnesses prior statement, so that testifies, they're subject to cross-examination about a prior statement, and that statement is inconsistent or is consistent with the declarant's testimony, and it's offered to rebut or express an implied charge that the declarant recently fabricated, rehabilitate credibility, or identifies a person as someone the declarant perceived earlier. This is what's more important. An opposing party statement. The statement is offered against an opposing party and was made by the party in an individual or representative capacity. This means any statements that the defendant made to anyone can be used in court under that rule, which takes them out of the scope of hearsay. Now, I won't get too far into it, but we have hearsay, we have non-hearsay, and we have not hearsay. So 3 different categories, and statements against an interest falls into that. So that kind of testimony is allowed. Nope, ballots were not duplicated. There was no finding of that. The courts affirmed that along with the lawsuit that was done by the voting machine company. All right, so the criminal agreement and acts to affect the object of the conspiracy. Again, we're going into this idea that 2 or more people were involved. The defendant's use of deceit to get state officials to subvert the legitimate election results and change electoral votes. So now the next part is going to be going into all of the different states and how each state was involved in this false elector situation. Why do we care about the false electors? Because, again, the false electors are part of obstructing influencing, right? So if you've got fake electors to come in and vote instead, or impeding, and there's evidence in the indictment, we'll get to that, saying specifically that to the vice president, hey, at least push the vote back further until we get the state legislatures to recertify any official proceeding. So it goes to these elements needed for the section of the code he's been charged with. All right, so back in here, we've got the evidence out of Arizona. Again, this is showing the how he went about this false elector scheme. So they're falsely asserting that non-citizens, non-residents, dead people had voted, and they hadn't. There was no proof of that, according to the Arizona House Speaker. Again, we have another witness. He asked for evidence. They didn't give him any evidence. Asked the House Speaker to call the legislature into session. This is another example of obstructing the legitimate electors. Here we've got to use the legislature to circumvent the process by which legitimate electors would be ascertained. Again, that is that disruption or impeding of that official proceeding from the government of going through with the electoral votes. So, and then this is just further information supporting that. So that's what we have for Arizona. We also have, of course, this public statement by the Arizona House Speaker. This statement could be brought in. It was a public statement made. As long as we pull in the House Speaker, he can testify to this, explaining that there was some questions being asked that he was uncomfortable with. So he's even going into that, like, hey, you guys asked me to do something and I'm uncomfortable and I'm not going to go against the rules. This is just another piece of evidence showing the way, the means, the conspiracy of multiple people came together in order to obstruct this proceeding from taking place on January 6th. Now we go here into co-conspirator 2 making a phone call. And that phone call can be testified to in court with the speaker on the stand. What the speaker heard as well as what the speaker said, this direct quote as well, can be used in court. We don't have hearsay issues because of the different rules that guard. The Supreme Court will deem this political speech. Okay, so let's talk about that for a minute. Let's just talk about it. On the morning of January 4th of 2021, co-conspirator 2 called the Arizona House Speaker to urge him to use a majority of the legislature to decertify the state's legitimate electors. That's the end of the sentence. So are you saying that's political speech? That co-conspirator 2 is asking the Arizona House Speaker to use a majority of the legislature to decertify their electors. So that request being made by this person to this person of power, are you saying that is political speech? I mean, legitimately asking, is that because I don't see how this is political speech, right? I mean, how is that political speech? Right. Yeah, I don't get it. I don't get it. We're not saying, I believe in this political ideology, don't you? No, they're saying, hey, you're in a position of power, put this body together and decertify electors. I mean, that's a request. That's absolutely a request, but I don't see how that would qualify as political speech. Okay. I mean, I think it's good to talk about. I mean, if we've got if we've got things to talk about, let's talk about it. But that is not political speech at this point. And so we can't use that for this. And this is a significant moment. We have a person close to the defendant asking a state official, to call in a legislative body to decertify legitimate electors. And that's pretty significant. Is asking illegal? Well, yes, I think that's the whole point. Yeah, you're not supposed to do that. You can't just ask. All right, hold on. Let me get control of myself here. If you are asking a legislative body to do something that is illegal, okay, that is wrong. Now, what we would call that technically, and I pulled this code section just for this very kind of question. Let me see here where I put it. Just one moment, please. Okay, so I've got two pieces here. First, all right, we've got obstruction of justice, so that's that. Okay, so there's that. And then we also have something called solicitation. And this is another inchoate offense. This particular code section is for a crime of violence, but it would be applicable even if there was no violence involved, with the intent to that another person engage in a conduct constituting a felony that has an element to use, attempted use, or threatened use. Again, physical force is specific to violence, but this is the crime. It's solicitation. When you're asking someone else to, and this is just the second part of the conspiracy piece. All right. So solicitation is a crime. You're asking someone to commit a crime. That is a crime. And if they agree, then they are also part of that. But in this situation, there was no agreement. So political speech does not save you from something like solicitation. So we have a specific code section for that, along with attempt and conspiracy as part of our inchoate offenses. The determination for solicitation will depend on your jurisdiction, but at a federal level, you know that something is a crime, and you're asking another person to commit that crime in exchange for something else. So that is what solicitation is. Now, I suppose you could come in and say, hey, I didn't know that if I asked the Arizona House Speaker to call in the legislature to decertify their legitimate electors, I didn't know that was a crime. Well, would an average person know or have reason to believe that that would be a criminal offense? If so, yeah, then there's the intent. And just because you didn't know doesn't mean that you cannot still be dinged on solicitation. So, again, those are our inchoate offenses, and we're dealing with those issues a lot here. We're dealing with attempt, we're dealing with conspiracy, and in some situations, solicitation, and not specifically, that's not been charged. But it could be. I mean, there's the elements are there, right? You're asking someone to do something illegal. Yes, cross would be it will be fascinating at all levels for both sides. Ignorance is no excuse. Well, it's not. It's not a good. It's not good. It's not. You're not going to win on, I just didn't know. Mistake of the law is not one of those defenses that you're going to plead and be able to get away with it. Free speech isn't a crime, but what you say shows intent. Right, and free speech, again, let's talk about that as well. Free speech, so we're dealing with government. We've got a government official here, so we're talking to a government official, the Arizona House Speaker. He's asking the Arizona House Speaker to do something. Now, again, when you're dealing with solicitation, which is a crime, when you're asking someone to commit a crime, that is not free speech. That is a crime. That falls outside of the scope of the First Amendment. And that's why we can have solicitation as a crime. Isn't solicitation when you ask for something in return, such as money or form of payment? It can be in exchange for something. It doesn't always have to be for money. It can be just in exchange for something. So you're asking someone to commit an offense. Now, if you're doing it together, you have a conspiracy. If you're doing it yourself, but you don't succeed, that's an attempt. If you're asking somebody else to do it, and whatever the exchange may be, it could be for a favor or for power or for, whatever, then that's solicitation. Those are the 3 inchoate offenses. And those are just fundamental principles in criminal law. Just warhorse fundamental foundational principles within criminal law. Right. Yes. I mean, co-conspirators is really what we're dealing with here a lot. And, in our inchoate offenses they're incredibly difficult to really wrap your mind around because we always have to have that act and intent. But when it comes to intent with inchoate offenses, it's kind of murky. So, all right, here we go, back into it. Arizona's validly ascertained electors had voted 3 weeks earlier, sent their votes to Congress, which was scheduled to count those votes in Biden's favor. Again, this is going to that official proceeding element of that section of the U.S. Code. In 2 days' time at January 6th, certification proceeding. Anytime they bring up certification proceeding, it is that element. When the Arizona House Speaker explained the state investigations had uncovered no evidence of substantial fraud in the state, co-conspirator 2 conceded that he didn't know enough about the facts on the ground. That's a direct quote. That means they must have someone who can go to the stand and testify about those words in Arizona, but nonetheless told the Arizona House Speaker to decertify and, quote, let the court sort it out. All right, again, so he's asking the Arizona House Speaker to decertify a legitimate set of people who were sent to be electors. The Arizona House Speaker refused, so now he's refused the solicitation. I'm just using that term again because there was an illegal act that was being asked to do, stating he would not play with the oath and that he had taken to uphold the United States Constitution and Arizona law, which is, absolutely valid. So, that sets out, again, co-conspirator 2. Now, the thing to keep in mind with co-conspirators is that they all get charged with the offense. So even though they've not been named here specifically in this particular indictment, they are seen as equal parties. So whatever role that they had as a co-conspirator, even if it was only just a little bit, you're still going to get charged with it because they're all part of it together. So what's good for one is good for everyone when it comes to co-conspirators. So you're saying it's solicitation. I'm saying this, if you look at the bare bones requirements for solicitation, and again, I've got the solicitation statute here. But it's specific to committing a crime of violence, but I'm showing it because it shows the elements of solicitation. So whoever with the intent that another person engage in a conduct constituting a felony that has an element of use or attempted use, and then this physical force element is specific to violence against property and so on, under the circumstances strongly corroborative of that intent, solicits, commands, induces, or otherwise endeavors to persuade such other person to engage in such conduct shall be imprisoned not more than 1/2 of the maximum term of imprisonment. So Again, I thought I had pulled every section I needed tonight, but I didn't pull out just solicitation. I pulled out solicitation to commit a crime of violence. And we're not talking about that here, but this is still the same language that would be used regarding solicitation when you're asking another person to commit a crime. So I would say, that could be argued. I could argue that. Yeah, the indictment's pretty strong. So, as far as just looking at it academically, again. All right, so we've got co-conspirator 2 asking the Arizona House Speaker to do something illegal, which is this. So that, could be seen as a solicitation. Maybe there's charges coming later, who knows, but... So the defendant publicly repeated the knowingly false claim to 36,000 that non-citizens had voted in Arizona. So he repeated that on January 6th. And this goes again to his actions that day in order to impede the proceeding. And now we've got Georgia. And here they're talking about problems with the voting machine. So now we've got co-conspirator 3 in on it. So again, they're showing this group of people all work together in order for this to happen. So they're going into different pieces of who did what, at what level, and it all led to his speech on January 6th. So all these parts came together, all this conspiracy came together in order to hinder the proceeding that was supposed to occur that day. And in fact, it did, because we did have that 6-hour delay. So here we go on this. We're discussing the voting machine issues and talking about what we needed in order to include those voting machines in our questions and our lawsuits. So really kind of pushing that narrative on that. But let's go down further into the evidentiary pieces, which is what we're talking about here. On December 3rd, co-conspirator 1, so now we've got 3 and 1, orchestrated a presentation to a judiciary subcommittee. Now, this presentation is also in question. What happens when you present false information to a subcommittee in front of the Georgia State Senate? That's a good question. Could there be a charge there? Yeah, probably. Could be. If he knew that information was false and presented it anyway, could be a charge. With the intent, and again, this is that intent, of misleading state senators. So if he knew it was false and went forward anyway in order to mislead state senators into blocking the ascertainment of legitimate electors. Again, this is interference with that official proceeding, which was the day of January 6th. During the presentation, so let's get into this evidence here. An agent of the defendant and co-conspirator 1 falsely claimed that more than 10,000 dead people voted in Georgia. That afternoon, a senior advisor to the defendant told the defendant's chief of staff through text messages, quote, and again, all of this can be admissible in court with the proper foundation and witness on the stand. Just an FYI, a campaign lawyer and his team verified that 10,000 plus supposed dead people voting in Georgia is not accurate. It was alleged in co-conspirator 1's hearing today. Again, that information, knowing that it's false and saying that in front of a subcommittee in a state senate, that seems like that could be an offense. The senior advisor clarified that he believed the actual number was 12. All right, so we've got that evidence that can be testified to in court. Another agent of the defendant and co-conspirator 1 played a misleading excerpt of a video recording of ballot counting at State Farm Arena in Atlanta and insinuated that it showed election workers counting suitcases of illegal ballots. So we have a misleading excerpt from a video. All right, so now that in and of itself would not be enough, I don't believe, in my opinion, my humble opinion. But taken along with the totality, it shows kind of this pattern of what's going on. And then co-conspirator 2 encouraged the legislators to decertify the state's legitimate electors based on false allegations of election fraud. And again, we've already talked about that. Asking someone to toss out the legitimate electors and replace them with fake electors is, not legal. We've got a tweet here. This, of course, is admissible. FYI, keep in mind that any kind of post on social media is not covered by the First Amendment. These are private companies, and the First Amendment covers government speech. So anything said on a social media account is not going to be protected. So just kind of keep that in mind, not legal advice, legal education. Tweeted amplifying the knowingly false claims made by co-conspirator one's presentation in Georgia. Quote, wow, blockbuster testimony taking place right now in Georgia. Ballot stuffing by Dems when Republicans were forced to leave the large counting room. Plenty more coming, but this alone leads to an easy win of the state. So this can be testified to. All they would need to do is bring someone in who knows that this was a tweet given by Mr. Trump, and this whole statement can go in as well. Again, it's going to kind of this idea of putting together a way to stop the proceeding on January 6th. That's the catch when you don't have specific allegations. No, conspiracy just means two or more people were involved in it. That's really what conspiracy is. So it's not, right here, it says if two or more persons conspire either to commit any offense against the United States or to defraud the United States. So that's a specific code section that's charged. So it's not just kind of a, potpourri miscellaneous charge. That's an actual charge. So we've got this tweet. This can be testified to in court with proper foundation and a witness. December 4th, the Secretary of State debunked the claims. So we've got a debuncation. Debuncation, is that a word? Issuing another tweet, which can also be testified to. The 90-second video of the election workers for the State Farm Arena purportedly to show fraud was watched in its entirety by these investigators, and it shows normal ballot processing. Here is a fact check on it. He reiterated during the press conference the claim that there had been misconduct at the State Farm Arena were false. He can testify to that. The defendant called the Georgia Attorney General to pressure him to support an election lawsuit. So he's trying to have a lawyer file a lawsuit, which would have been unethical, in the Supreme Court by another state's Attorney General, which again is unethical. The Georgia Attorney General told the defendant that officials had investigated various claims of election fraud in the state and were not seeing evidence to support it. So now we have the state's Attorney General saying, hey, I can't file a lawsuit, there's no evidence. So there you go. On December 8th, the campaign advisor who spoke with the defendant on a daily basis informed him multiple occasions that various fraud claims were untrue, expressed frustration that many of co-conspirator one and his legal team's claim could not be substantiated. We've got this issue of the large number of dead voters was untrue, and he was told of that. When our research and campaign legal team can't back up any of the claims made by our elite strike force legal team, you can see why we're 0 for 32. That's pretty significant. Senior campaign advisor wrote that. He can be called to testify or subpoenaed. I'll obviously hustle to help on all fronts, but it's tough to own any of this when it's all just conspiracy beamed down from the mothership. So again, that statement can be testified to in court. It's possible. We've got 4 days before the properly pulled in electors were scheduled to cast their votes, appeared at a hearing before the House of Representatives. Now we've got another hearing. So here's number 2. We've got co-conspirator one played the video again, falsely claimed, quote, voter fraud right in front of people's eyes, and it was the tip of the iceberg. Then he cited 2 election workers by name. So this could, let's put this down, defamation, right? He's pulling out 2 election workers by names and saying, quite obviously, surreptitiously passing around USB ports as if they're vials of this kind of drug. Now, one of the very oldest doctrines that we have in this country is defamation of bad character by doing something like using an illegal substance or other things of that kind of nature. Those are the very at the very core of defamation doctrine, and suggested that they were criminals. Wow. That's also another huge defamation, whose places of work, their homes, should have been searched for evidence of ballots, for evidence of USB ports, for evidence of voter fraud. Thereafter, the 2 election workers received numerous death threats. And that would be the harm that came to them. If they were to go forward in a civil lawsuit, they would be able to say, hey, we were given death threats, dude, so, we've got damages. I would say that's a defamation lawsuit possibility. They should sue. Oh, they have. Okay. They have. Well, that's interesting. I'm glad to hear. They did. Okay. They did sue. I might look into that. I would be very interested to see what happened there, because that's some pretty significant, just absolutely textbook defamation. Textbook. And in fact, they could even bring in those election workers to testify, to say, hey, this was said about us, and, we had death threats, and it's not true. Again, going to this conspirator idea that they're putting together all of these different pieces. Oh, okay. Thank you, VC. Thank you. Good to know. Good. Oh, good. I can't even imagine how long or how difficult this would have been for them, where he's just picking some people out of a video and claiming that they have messed with the election. So, that's awful when you're involving other people at this level. It's one thing, we all have our feelings about government officials, but we've just got people counting votes and doing like volunteer work, essentially, or very low paid work to try to, help out. And then they're pulled in like this. My goodness, that's not so good. All right. So we've got the defendant summoning the incoming acting attorney general, incoming acting deputy attorney general, others to the Oval Office to discuss allegations of election fraud. So now we've got more attorneys that are talking to him about it and saying that this tape was benign. So even that's just more evidence supporting that. Yet, again, if we pop back up here, we see he presented it to this Georgia House of Representatives Government Affairs Committee. So could there be a charge here? Possibly. We will see. Oh, honestly, I've had it for so long, I don't remember where I got my ring. Yes, I believe people have talked about Giuliani being co-conspirator one. I think that's what people have come together to say. Now, it's not listed in the indictment, so I say that we would say in the business that's like a soft confirmation. That's not rock hard. I don't know, but I think that is definitely a piece. He's playing a role here, so it would make sense. I think he did do, if memory serves, he was out kind of circling this situation quite a bit. So, all right, December 23rd, we've got signature verification process, notified the defendant, state election officials were conducting themselves in an exemplary fashion. So we've got confirmation there's nothing wrong with the state election officials, would find fraud if it was there. And then he tweeted out, and again, this can be testified to, that they were terrible people because there was no finding of fraud. December 27th, he spoke with the acting attorney general, acting deputy attorney general. During the call, the defendant again pressed the unfounded claims regarding State Farm Arena, and the two top Justice Department officials again rebutted the allegations, telling him that the Justice Department had reviewed videotape and interviewed witnesses. So they did investigate, and they had not identified any suspicious conduct. Again, they can be called in to testify then in trial. The 31st signed a verification affirming false election fraud allegations. Now, this signature here for this lawsuit, again, is at a minimum obstruction of justice, I would say here. But now we've got a signature. So we've got an actual document where he's filing a lawsuit against the Georgia governor. acknowledged in an email, so we must have the email. There's another piece of evidence. He and the defendant had, since signing the previous verification, afterwards been made aware that some of the allegations and evidence proffered by the experts has been inaccurate, and that signing a new affirmation with that knowledge and incorporation by reference would not be accurate. So he's acknowledging the inaccuracy. If they were to do it again, the defendant and co-conspirator to cause the defendant's signed verification to be filed nonetheless. All right, so they knew that it was false. They had information after they created it, and rather than fixing it, they filed it anyway. So they knowingly filed false information. That would be another charge that could be looked at as well. He has the constitutional rights to free speech if he truly thought he had been cheated. Okay, well, freedom of speech, yes. You don't have freedom of speech to file false documentation with a court. So that's just against the law. There's no freedom of speech protection for that. So you can go in front of the courthouse and say a bunch of very bad words, and if it's zoned properly, you can set stuff on fire, but you can't file false documents in court. That's just not, that's just against the law. That's not a freedom of speech issue. So with that, yeah, it's not. If you know the documents are false and you file it, if you're an attorney, you can lose your license. You can absolutely lose your license for that. So it's just, yeah, it says they knew with that knowledge and incorporation by reference would not be accurate. So there's an email where co-conspirator 2 and the defendant knew and wrote out they knew that it was false, but they filed it nevertheless. So yes, perjury. Yeah, it's like that, only on a different end. We call it something a little bit different. Intentionally filing a false documents would be a charge. So, yeah, I don't know really what has happened with our freedom of speech education. But I have to say, in all honesty, there are so many people that just really don't understand how it works, and I think we really just haven't taught it properly to people. So I'm not sure there's like an intentional lack of knowledge. I think it's just been something that was not set out properly, maybe. And so that's it's not taught properly. That's what I'm guessing. Because there are so many situations where freedom of speech is regulated, and people, will say, hey, I've got freedom of speech. So I'm like, wow, that doesn't apply here. Like, I'm not the government. It doesn't apply to me. So I don't have to, it's tough. I think they don't do civics anymore. And that's a shame, I think. I try really to share a lot of civics with my TikTok. I do my best, but you really just don't know what other people don't know until they tell you. And so at that moment, you just pause and say, okay, let's start from the beginning here, and let's get back to the basics, which is, this is a Wendy's. No, sir, this is not a Wendy's. Yes. All right, so let me keep going here. We've got a bit more evidence. Again, I'm not reading through this whole indictment tonight. I'm just going through the different pieces of evidence and kind of explaining it on that. I've been, several people have tagged me in, yeah, it's not Wendy's. Ma'am, this is a Wendy's. No, it's not. Several people have tagged me in some Fox News videos, but the information is just incorrect with the ones that I've been tagged on. Maybe there is good information out there. I don't spend a lot of time looking at the news like that. I have my own resources that I look through, but there's some very interesting things, especially on freedom of speech, that has been put out there that's just like, blows my hair back. It's just so like, what? Like, I want to write them a letter and be like, dear sir or madam, can you please read that First Amendment again? That would be great. But, whatever. Yeah, it's something. It's something. And I'm not saying the other channels don't. I'm certainly not going to say that. I'm saying I think there's just an overall misunderstanding, I think. All right, so here we go. Off of my soapbox now. On January 2nd, 4 days before Congress's certification proceeding, defendants and others called the Georgia Secretary of State. Now, we've got this phone call, and this is pretty difficult because of what was asked of this Georgia Secretary of State. When we hop down to this evidence, we have direct quotes in here. I don't care about the link. I don't need it. I have much. Georgia Secretary of State. I have a much better link. So this information and these direct quotes, they must have evidence with that language in it. So they would just need to call this witness in to testify to whatever source of evidence. I don't know if it's a recording or if it's notes that were taken. I think with this kind of accuracy, it's probably going to be recordings. So that recording would be played in front of the jury. So using her name almost 20 times, falsely referring to her as a professional vote scammer and a hustler. In response, Georgia Secretary of State refuted this, quoting, "You're talking about the State Farm video, and I think it's extremely unfortunate that co-conspirator 1 or his people, they sliced and diced that video and took it out of context." When the Georgia Secretary of State then offered a link to a video that would disprove co-conspirator 1's claim, the defendant responded, "I don't care about a link. I don't need it. I have a much better link." So this has somehow been recorded verbatim and will be able to be, he recorded the call. Okay, I'm wondering, because that's what it sounds like. It sounds like it's been recorded because this level of detail is typically not word for word. Oh, well, thank you so much, Serena. Oh, my goodness. But yeah, so we would just call in this Georgia Secretary of State, and I think he would have a lot to testify to if he was called in, or when he gets called in. I have no doubt he's going to play a key role here. The defendant asked about rumors that paper ballots cast in the election were being destroyed. So the Georgia Secretary of State's counsel, so now we've got the counsel involved, explained to him that the claim had been investigated was not true. He claimed 5,000 dead people voted in Georgia, causing the Georgia Secretary of State to respond, quote again, so we must have another recording. "Well, Mr. President, the challenge that you have is that the data you have is wrong. The actual number is two people that were dead and that voted. And so your information is wrong. That was 2. So again, we have another probably tape is what I would assume here. Oh, okay. Yes. Okay, one-party consent. Well, I mean, even if it's, you can always argue those kinds of issues too. So depending on the circumstances. But that's really good to know about Georgia. Okay, so we've got a tape that'll come in as evidence. The defendant claimed that thousands of out-of-state voters had cast ballots in Georgia's election, which the Georgia Secretary of State's counsel refuted, explaining, quote, "We've been going through each of those as well, and those numbers that we got, the defendant's counsel was just saying they're not accurate. Every one we've been through are people that lived in Georgia, moved to a different state, then moved back to Georgia legitimately. They moved back in years ago. This was not like something just before the election." So again, we've got another tape here. In response to multiple other of the defendant's allegations, Georgia Secretary of State's counsel. So let's just take a moment and recognize what's going on here. We have the Georgia Secretary of State. His lawyer is the one who's talking to the defendant at this point. So what is it where we've gotten to a point where the defendant was speaking to the Secretary of State, and at some point the Secretary of State called his lawyer and said, "You're going to need to talk to the president because I'm not going to." Let's just kind of pause for a moment and say what happened here to make that. Yeah, the lawyer got lawyers. Exactly. I mean, that's pretty significant where the Georgia Secretary of State is in a position where he needs to have legal counsel. And he told the defendant that the Georgia Bureau of Investigation was examining all such claims and finding no merit to them. The defendant said that he needed to find, and this is not very good, 11,780 votes, and insinuated that the Georgia Secretary of State and his counsel, all right, so now we've got this guy and this guy, could be subject to criminal prosecution if they failed to find election fraud as he demanded. So now are we dealing with threats here? Do we have threats? Um, I think that sounds like a threat to me. He needed the votes. What's wrong with that? Well, I mean, yeah. Yes, that's one way. Oh my goodness gracious. All right, so criminal prosecution if they failed to find it. So we've got some threats going on. And you're going to find that they are, which is totally illegal. It's more illegal for you than it is for them. Wow, because you know what they did and you're not reporting it. That's a criminal. That's a criminal offense. And you can't let that happen. That's a big risk to you and the Georgia Secretary of State's counsel, your lawyer. So now at this point, again, we must have another recording. That's pretty damaging. I mean, this is an illegal act to ask for more votes or insinuating that there could be criminal sanctions if you didn't find any more votes. Now imagine, just for a moment, imagine getting a call from the President of the United States after an election asking you to find votes, or you could be looking at jail time. I mean, that's pretty, I would be pretty freaked out. Like, what am I supposed to say? He's the President of the United States on the phone asking for votes or saying, I'm going to be, charged with something. And he's like, I mean, that's scary. That's scary. I mean, look at the differing power levels and the power of the office of the President of the United States, asking for something at this level. I mean, I'm just taking a moment to try to put myself into the shoes of these guys getting this phone call asking for votes. Because first of all, it's like, we're not at a pub having a few pints asking like, hey, wouldn't it be fun if we got extra votes? No, this guy called him and said, find me the votes or you could go to jail. And that's a lot. That's really a lot. I mean, that to me, it seems like a lot. You are reading into it. He's not saying that at all. Okay. Defendant said that he needed to find 11,700 votes. I'm not sure what part I'm reading into that. I mean, I'm reading it, but we will see what happens here. I know. I mean, it looks like he's saying that. I don't want to be biased, but it looks like that's what he said. He said, find me the votes or, that's criminal. It's a criminal offense. And, that's a big risk for you and your lawyer. I mean, that's direct quotes. We will see what happens. Maybe this isn't written correctly, but you heard the phone call. Okay. I'll have to look this up. I really need to do more, more looking into it. I've tried to stay kind of away. I'm just trying to keep my eyes on the, document itself, but oh my goodness. Highlight risk. All right. Let's see. Ooh, that's a big risk. Ooh, good point. Ooh, sharp eyes. Okay. So we will, I mean, there's a lot. That's a lot. I don't know what would happen if it was me. I would be like, okay, here's the votes. Like, get off the phone. Oh my gosh, what am I going to do? I would totally be intimidated. Absolutely be intimidated if that happened to me. All right, here we go. So the next day, January 3rd, he falsely claimed the Georgia Secretary of State had not addressed the defendant's allegations. And I wonder again how that Secretary of State's feeling the next day after that phone call with the President of the United States. So here we go. Publicly stating he was unwilling or unable to answer questions such as ballots under table scam, ballot destruction, out-of-state voters, dead voters, and more. He has no clue. Again, this is going to be able to be used in court. January 6th, the defendant publicly repeated the knowingly false insinuation that more than this many people had voted. And again, at the end of every section with each state, they're setting out what he said that day, because of course that was the day of the proceeding. So that's what he's been charged with, is interference with that proceeding. All right, so here's Michigan. Now, this one in Michigan has to do with a dump of votes. And this is a little bit different. He's got a quote saying that, everything in Detroit is corrupted anyway. Final batches were coming in. Nobody knew where they came from. So this would be able to be testified to in court. The governor signed a certificate of ascertainment notifying the federal government, based on the popular vote, the electors were to represent Michigan's voters. So we have that information. Oh, yes, exactly. So we've got this information. We've got the Speaker of the House of Representatives and the Majority Leader. False claims again of illegitimate voting dump in Detroit. And they said that he lost in Michigan not because of fraud, but because the defendant had underperformed in certain voter populations in the state. I'm going to take it just a minute and say that does not surprise me that came out of Michigan, where they're on the phone with the president. You know, previously they're like, oh my gosh, he wants to find votes. But in Michigan, they're like, dude, you just screwed up your campaign. Oh my goodness. Again, I'm making extra information here with my 2 cents, but I mean, it's fascinating. So they're like, dude, you messed up. So here we go. Upon leaving their meeting, the Michigan House Speaker and Michigan Senate Majority Leader, and they're not playing around in Michigan. I mean, if you've ever been to Detroit, they are not messing around. The Senate and House Oversight Committees are actively engaged in a thorough review of Michigan's elections process. We have faith in the committee process to provide greater transparency and accountability to our citizens. We have not yet been made aware of any information that would change the outcome of the election in Michigan, and as legislative leaders, we will follow the law and follow the normal process regarding Michigan's electors, just as we have said throughout the election. So this is their statement, and of course, they can be called in to testify. So he went on, talked again about this voting dump in Michigan, and had said again, the Attorney General was saying, hey, this was a normal voting counting, and it was absolutely fine. So here we go. The next day, he said, quote, again, 6:31 in the morning, the vote dump of 149,772 votes came in unexpectedly. We were winning by lot. That batch was received in horror. Nobody knows anything about it. It's corrupt. Detroit is corrupt. I have a lot of friends in Detroit. They know it, but Detroit is totally corrupt. So that, again, is a direct quote that can be testified to in court. I'm wondering what he means by this, by I have a lot of friends in Detroit. Maybe he had some people in Detroit that were saying this to him, that were saying there was this vote dump. And if that's the case, like, who are these people that were giving him false information? I don't know. I mean, I'm just guessing here. I'm just guessing. But if he's mentioning he's got friends in Detroit, that makes you question, well, you know, what are they telling him then? I mean, it's something to think about. Or maybe he's just saying, you know, I'm just like you. I know someone in Detroit. I'm cool too. And they know it's corrupt. So, you know, I don't know. I really don't. I can't speak to his motivation. But if research is done and they are found to find some people that were giving some information falsely, it could be it. All right, here we go. December 4th, co-conspirator 1 sent a text message to the Michigan House Speaker reiterating his unsupported claim of election fraud. And that bumps us down to the next quote. Looks like Georgia may well hold some factual hearings and change the certification under Article 2, Section 1, Clause 2 of the Constitution. As co-conspirator 2 explained, they don't have just the right to do it, but the obligation. Help me get this done in Michigan. That could be some significant pressure here, pressuring to say, again, kind of like that Georgia pressure where it's like, you know, you guys could be looking at jail if you don't find me the votes. But in this case, it's more like, help me get this done, you know, ... I don't know. Again, I'm just asking that in general because this could be testified to. It could go to show that he knows he needs help in order to win Michigan, which means he knows he's lost it. I don't know. Yeah, I mean, I don't know. We're just kind of talking through it here with that. Yeah, he was lying. That's what they're saying. It was false when he said Georgia was going to look into it again. That's false. That's absolutely false. And he used that as leverage to try to push Michigan. But again, Michigan's really a different animal. So, all right, if you will just stay with me here for one moment, I need to plug in my battery so I can keep going here, so just one moment, please. Okay, now let me make sure I'm back up okay. Let me just, am I in frame okay for everybody? Okay, good. Thank you, John. I appreciate that. Oh, yes. Okay, good. All right, let's dive right back on in. All right, so let's hop down again to the next quote. So I need you to pass a joint resolution. All right, that just right out the gate. Conspirator 1 sent a text that is allowable in court to the Michigan Senate Majority Leader. I need you to pass a joint resolution from the Michigan legislature that states that the election is in dispute, that there's an ongoing investigation by the legislature, and the electors sent by Governor Whitmer are not the official electors of the state of Michigan and do not fall within the safe harbor deadline of December 8th. That's a pretty significant quote, specifically soliciting this kind of conduct. So that, of course, could be used in court as evidence. Next, December 14th, the day the electors in the states across the country were required to vote and submit their votes to Congress, the Michigan House Speaker and Michigan Senate Majority Leader announced that, contrary to the defendant's request, they would not decertify the legitimate election results or electors in Michigan. The Michigan Senate Majority Leader's public statement, which again could be admissible in court, we have not received evidence of fraud on a scale that would change the outcome of the election in Michigan. And the Michigan House Speaker's public statement read, we've diligently examined these reports of fraud to the best of our ability. I fought hard for the president. Nobody wanted him to win more than me. I think he's done an incredible job, but I love our republic too. I can't fathom risking our norms, traditions, and institutions to pass a resolution retroactively, which is not good, changing the electors for Trump simply because some think there may have been enough widespread fraud to give him the win. That's unprecedented for good reason, and that's why there's not enough support in the House to cast a new slate of electors. We fear we'd lose our country forever. This truly would bring mutually assured destruction for every future election in regards to the Electoral College, and I can't stand for that. I won't. That's a pretty powerful statement. Yes, this right here is free speech. Absolutely, this is free speech. So this is a government person making a statement to and about the government. This is absolutely free speech, 100%. 100%. So this statement, again, we would call in this person as a witness to come in and testify. Again, we're bringing up January 6th, where he publicly repeated he knowingly made this false claim regarding this dump in Detroit. Again, attaching this statement with his actions on January 6th, which was the obstruction of the official proceeding. So tying that again to those counts that had been issued earlier. So Pennsylvania, let's get into Pennsylvania a little bit. We've got already the defendant publicly maligned a Philadelphia city commissioner for stating on the news there was no evidence of widespread fraud in Philadelphia. He and his family received death threats. Again, we could have another publicly maligned. We could have a defamation situation if the statements he said were untrue. I don't know what statements they were, but if he sustained damages because of that, it could be a defamation. Now, words alone are not enough. If he's just saying, you're a bad person, that's not going to rise to the level of defamation. But if he's starting to say something really awful about him personally, now we could be looking at a defamation. I don't know the details, so I don't know if that's correct or not. Yes, this is the indictment filed by the grand jury. So on December 25th, the day of Pennsylvania governor signed a certificate of ascertainment and thus certified to the federal government, again, part of that government process that he's being charged with interference with. co-conspirator 1 orchestrated an event in Gettysburg attended by state legislators. Co-conspirator 1 falsely claimed Pennsylvania had issued 1.8 million absentee ballots and received 2.5 million in return. Campaign staffer wrote that it was just wrong. There's no way to defend it. So again, we've got another witness here and an internal document. So all of that is evidence that can come in at trial as well. That the deputy campaign manager responded, "We've been saying this for a while. It's very frustrating." Again, we have another witness here. On December 4th, they did a public statement. The General Assembly lacked the authority to overturn the popular vote. That's a pretty significant public statement. Again, showing this attempt of trying to ask the General Assembly to overturn the popular vote. Even asking this question goes to the intent of interrupting this government proceeding, which is what he's charged with. So, on the 31st and January 3rd, the defendant repeatedly raised with the acting attorney general and acting deputy attorney general the allegation that in Pennsylvania there had been 205,000 more votes than voters. Each time, the Justice Department officials informed the defendant that his claim was false. Again, all we would need are these officials to come in and say, "Hey, we told him," repeatedly. So, drawing it together again with January 6th. So he knowingly made these statements on January 6th. And again, this idea of with the intent to interrupt the official government proceeding. And just one more time to remind everybody of what the charge is. He's charged with otherwise obstructing, influencing, or impeding any official proceeding or attempting to do so. That's the crime he's charged with doing. So this is going into more of tying that in on January 6th. That's when that proceeding occurred. And so this is what he did that hindered that proceeding. And that's where we got the criminal charges from. All right, so that's the last piece for Pennsylvania. And then we've got Wisconsin. We've got a recount in Wisconsin that he petitioned and paid for. And it had actually increased his margin of defeat. So I guess there was some showing that it was incorrect to some degree. The Supreme Court rejected the election challenge by the campaign, and then we've got a direct quote from a judge. "Nothing in this case casts any legitimate doubt that the people of Wisconsin lawfully chose Vice President Biden and Senator Harris to be the next leaders of our great country." So we've got an actual judge saying that. So you've got to look to that credibility factor when we've got a judge involved. December 21st, Wisconsin governor who signed the certificate of ascertainment on November 30th, identifying Biden's electors, signed a certificate of final determination in which he recognized the state Supreme Court had resolved the controversy. So he set that out. So we've got that. Now we've got a response to that. The defendant issued a tweet repeating this knowingly false claim, even after the governor had said, both myself as governor and the Supreme Court said there's no fraud. So he came out in a tweet later and repeated the false claim of election fraud, demanding the legislature overturn the election results. He talked again to the acting attorney general, and they said again the claim was false, and then we're drawing it back again to January 6th, where he publicly repeated these knowingly false claims. And again, we're just going into, what elements are needed for the charges. Now, the defendant's use of dishonesty, fraud, and deceit to organize fraudulent slates of electors and cause them to transmit false certificates to Congress. Now, again, these fraudulent slates of electors is going to interfere with that official government proceeding. Yeah, Twitter is not the government, so they can kind of, I don't know what it is now. I'm not, whatever it's called now, whatever entity that once was is not a government body. So we've got further going into say the attempts to obstruct the electoral vote, which is that proceeding that they're saying he violated or tried to keep from going on through deceit with repeated failure in these targeted states. And they tried to make then the vice president and Congress send in different false certifications in order to surpass those legitimate electors. Under the plan, the submission of these fraudulent slates would create a fake controversy. So this is another situation where they're saying this is going to mess up the certification proceeding, which is the proceeding that they're claiming he again, I just pull this out just to make sure everyone knows what I'm talking about when he's been charged. He's obstructing. This is an obstruction of justice code section. And they're talking that he's obstructing an official proceeding. So they're saying this is what he did on January 6th. That's the date and time of the proceeding. And in order to obstruct it, they tried to create this fake controversy that would put the vice president in a position when he was presiding on January 6th of, as president of the Senate in his role, in order to create this controversy that would slow everything down. Okay, so that takes us then into the evidence regarding this process of trying to get these fake electors in order to mess up the process. So we're trying to, what they're saying is, the plan was subverting the federal government function by stopping Biden electors' votes from being counted and certified. So this is that obstruction of an official government proceeding. Okay? First one, November 18th memorandum, the Wisconsin memo, advocated that because of the ongoing recount in Wisconsin, the defendants' electors there should meet and cast votes on December 14th, the date of the ECA required appointed electors to vote, to preserve the alternative of the defendant's Wisconsin elector slate in the event the defendant ultimately prevailed in the state. So that's part one. Now we've got the next part, the fraudulent elector memo. All of this evidence is going to be able to be presented, showing again how they tried to subvert the federal government function by stopping these electors, the legitimate electors, by bringing in fake ones. So they're trying to stop the proceeding. That's the violation of the United States Code. Marked a sharp departure from Co-Conspirator 5's Wisconsin memo, advocating that the alternate electors originally conceived of to preserve rights in Wisconsin instead be used in a number of states as fraudulent electors to prevent Biden from receiving the 270 electoral votes necessary to secure the presidency on January 6th. So again, this is when the proceeding is to take place, and this is the plan on how they're trying to obstruct it. The fraudulent elector memo suggests that the defendants' electors in 6 purportedly contested states, Arizona, Georgia, Michigan, Nevada, Pennsylvania, Wisconsin, should meet and mimic as best as possible the actions of the legitimate Biden electors, and that on January 6th, the vice president should open and count the fraudulent votes, setting up a fake controversy that would derail the proper certification of Biden as the president-elect. So this, again, is that act that's in violation of the United States Code for coming in and obstructing that proceeding from going forward, which is a violation of that U.S. Code section. And then here's the third one, December 9th memorandum, the fraudulent elector instructions. Consisted of Co-Conspirator 5's instructions on how fraudulent electors could mimic legitimate electors. So we're trying to mimic legitimate, and we've got fraudulent electors in Arizona, Georgia, Michigan, Nevada, Pennsylvania, Wisconsin. Co-Conspirator 5 noted that in some states, it would be virtually impossible for the fraudulent electors to successfully take the same steps as the legitimate electors. So this goes to acknowledging that they even knew that they were going to have problems getting the fraudulent electors in, because state law required formal participation in the process by the state officials or access to official resources. So they knew that there could be a problem. So that, again, is acknowledging that what they're doing could face problems because their electors were fraudulent. The plan began in early December. Ultimately, the conspirators in the defendant's campaign took the Wisconsin memo, expanded it to any state the defendant claimed was contested. So they went further on. We've got a writing here. We just need to have someone coordinating the electors for the states. This goes to the conspiracy element. There are multiple people involved in this fake elector. And by having these fake electors, would they get actually sworn in and substitute for the legitimate electors? Not necessarily, but the plan wasn't necessarily that they would cast votes properly for Mr. Trump. The plan was that they would interrupt the proceeding, which is what he's being charged with. December 6th, defendant counsel 2 called the chairwoman of the Republican National Committee to ensure the plan was in motion. So now we've got another character here who can be called in to testify, and she is part of the Republican National Committee and trying to help the defendant's campaign gather electors in targeted states. But this is a key piece. They falsely represented to her that such electors' votes would be used only if ongoing litigation in one of those states changed the results. So she was given incorrect information that she believed and based her actions off of that. So this is something that we would call mitigating circumstances. So if we were to go forward and try to charge her with her role in the situation, we would have to look and she would say, look, I thought they were telling me the truth. And, what reason would she have to not believe them, I guess would be a good question. That they said this was only going to be used if we won in litigation. So she may have had this good faith idea of saying, hey, okay, yeah, sure, I'll help out. Not realizing that the information she was given was false. So it's possible she should have known. Yeah, I mean, that's a good question. Should she have known? I really don't know. Should she have had the understanding that what they were asking her to do was part of a bigger scheme? Should she have known that? I don't know. I really don't know. She's saying, here, because they're using this term falsely represented, she's, reducing her intent level, saying, I didn't have any reason to doubt them or whatever. So this is going to be a question for the jury to determine. This is why our fact finders are so important, because when she's up there testifying and saying, hey, I had no idea, they're going to need to make that determination. Is she telling the truth? Is she credible or not? I mean, we don't know at this point. So far, I mean, we don't. Right. It's hard to tell. I mean, it's hard to tell exactly what's going on. It doesn't look good, but I think the fact that these two words are included here goes to how the indictment was presented to that grand jury when it came to her intent and her culpability in the situation. I don't know. I think it's worth taking a moment, pause for that. Yes, I mean, it is pretty bad. If something's illegal and you don't want your name associated with it, you're probably already too far along to really get out of it carefully. So on December 7th, co-conspirator 1 received the Wisconsin memo and the fraudulent elector memo. Okay, they asked about which attorneys could assist them, which that's a huge ethical violation. Huge right here. In the targeted states, he received from co-conspirator 6 an email identifying attorneys in these states. And that's distressing. The next day, December 8th, co-conspirator 5 called the Arizona attorney on the list. In an email after the call, the Arizona attorney, I'm wondering who this person is. Do we know who this person is? As I ask all of you guys for all the details. But, so this Arizona attorney, and then wrote later, I just talked to the gentleman who did that memo. His idea is basically that all of us have our electors send in their votes, even though their votes aren't legal under federal law. So there's an acknowledgement of the illegality of it because they're not signed by the governor, so that members of Congress can fight about whether they should be counted on January 6th. Again, this is showing that interruption in that government proceeding. They could potentially argue that they're not bound by federal law because they're Congress and make the laws. Kind of wild, creative. I'm happy to discuss This isn't helping this Arizona attorney at all. My comment to him was that I guess there's no harm in it. Legally, at least, we would just be sending in fake electoral votes to Pence. Is that sarcasm? Am I that dense that I'm not catching that as sarcasm? So that someone in Congress can make an objection when they start counting votes and start arguing that the fake votes should be counted. Is he kidding? Are we joking here? I don't know. It's hard to tell sometimes. Yes, just the facts. And, again, I can't tell. Is this really what he's not? Okay. Oh my gosh. Yikes. Yes. Oh, thank you so much for the mods. My mods are so fantastic. Thank you. Yes, conspiracy to obstruct. Yes. I mean, if again, I'm not sure. I can't quite figure out just based off of the words if he's kidding or not. I think that's a good question. They said only 2. Yes, true. So true. That's sarcastic. Okay, yeah, I don't know. I think we'll find out. We will find out. I have a hard time, I'm not sure what it is. I think it can go either way. All right, so on December 10th, sent out points of contact along with the fraudulent elector certificates. Next day, co-conspirator 5-1 suggested that the lawyer file a petition for cert in the Supreme Court as a pretext. Explained that co-conspirator 1 had heard from a state official and state provisional elector that it could appear treasonous for the Arizona electors to vote on Monday if there was no pending court proceeding. So we have this filing again of cert. Now, if you're filing a cert with bad information, that's another ethical concern. We've got electors expressing concern about signing those certificates. They just said, assured them the certificates would only be used if the defendant succeeded in litigation. So again, we have this misrepresentation to these fake electors. Subsequently circulated proposed conditional language. And then we've got another quote here. The other states are signing what he prepared. If it gets out, we're changing the language for Pennsylvania. It could snowball. That also goes to the intent that they're saying we kind of know that this is an issue and we don't want to tell other people about it because they may ask for changes too. Some cases, the defendant's electors refuse to participate in the plan. Now, these people can be called to testify and asked about, well, who asked you and what did they ask you to do? And what was the plan? So all of those things. What's my pen? It's big. Not much ink left in there. I do a lot of marking up of different pages, but yes. So I would say these electors would be called in, the ones that refused. The fact that they know some refused means that they must have a list. December 13th, co-conspirator 5 sent to co-conspirator 1 an email memorandum. So we've got documentation evidence there. Let's see, not using the electors, only in the circumstance the defendant's litigation was successful in one of the targeted states. Instead, they were going to falsely present the fraudulent states as an alternative to the legitimate states. So now rather than saying, hey, we're just going to keep these in case the litigation succeed, we're saying we're going to go ahead and present those. What's going on with the elector plan? Put a statement on the electors out. Here's the thing, the way this has morphed, it's a crazy plan. So I don't know who wants to put their name on it. That is never a good sign when they're like, are you in or not? Isn't that the moment in the movies when things start to take a bad turn? I mean, I'm just saying. The senior advisor wrote, certifying illegal votes. In turn, the participants in the group text message refused to have a statement regarding electors attributed to their names because none of them could stand by it. So we're certifying illegal votes. We know that that's illegal and that is wrong to do that. So campaign staffers request drafted and sent fraudulent elector certificates for the defendants' electors in New Mexico, which hadn't even been involved. The next day, they filed a lawsuit then in Mexico. That's a big question. Filing a knowingly false lawsuit is a huge ethical violation. On the 14th, the electors of all 50 states and the District of Columbia met their respective jurisdictions to formally cast their votes for president, resulting in a total of 232 for the defendant and 306 for Biden. The legitimate electoral votes that Biden won in the states that the defendant targeted, defendant's margin of defeat was as follows. So Arizona, 10,457, Georgia, 11,779, Michigan, 154,000, Nevada, 33,000, New Mexico, 99,000, Pennsylvania, 80,000, Wisconsin, 20,602, 682 votes. They convened the sham proceedings at the same time in the 7 targeted states. So they're going to have evidence of that, of who set that up, who was involved, and all of the people that were involved in actually the practicality of getting these fake electors in to do the proceedings. All of those people will be able to be called in. The co-conspirator 5 had predicted in the fraudulent elector instructions the fraudulent electors were unable to satisfy the legal requirements. And we've got some state officials enlisted to provide access to Capitol buildings. So I'm wondering who these state officials are too. And can they be called in? Can they be charged as part of the conspiracy? I don't know. Yeah. Oh, good point. How many did he ask for in Georgia? Right? He asked for, let's just take a moment and go back to Georgia. So, I mean, that's a good point. This is a piece of evidence that they've got, and he's asking for 11,780 votes. And in Georgia, we have 11,779. Wow. Oh my goodness. Okay. So he knew the number. He knew how many to ask for. That's interesting. Very interesting. 16 people have been charged in Michigan. Right. And I think a lot of that information during their criminal discovery process will be interesting. Yes. See, isn't that interesting? He asked for 11,780. It's like he knew. Yeah. I mean, isn't that interesting? Very interesting. Okay. Thank you for bringing that point up. Excellent. All right. Nonetheless, directed shortly after the fraudulent electors met, December 14th, the targeted states certificates were mailed to the president. So now they're using this is another good question too. They're using the mail as a mode to perpetuate a crime. Now that could be a charge, right? Anything going through the mail illegally, if it's a piece of illegal whatevers, in order to use the mail to perpetuate a crime, you can charge on that. Mailed to the President of the Senate, the Archivist, and the United States and others. Defendant co-conspirators ultimately used the certificates of these fraudulent electors to deceitfully target the government function, which again is that essential element to that 18 U.S. Code section 1215 that we've been going through. Let me make sure I said that section right. Nope, sorry. 1512. I'm backwards. 1512 C2. Obstructing, influencing, or impeding any official proceeding or attempting to do so. So that takes us over here. Legitimate electors' signed certificates were annexed to the state's executive certificates of ascertainment before being sent to the President of the Senate. So the chairwoman forwarded to the defendant through his executive assistant an email, which of course, they have this email, with a recap of the final. And then we've got another witness here, an executive assistant, who responded that she gave him the email. So there is that set of evidence as well. Yeah. I think actually just looking at the words themselves is, I mean, that's kind of what I find to be for myself. It helps me at least because I really don't have all the information, but when I read it like this, I'm like, okay, well, let's break it apart and see what it really says and what's going on here. The defendants attempt to leverage the Justice Department to use deceit to get state officials to replace legitimate electors and electoral votes with the defendants. Again, going to this obstruction of that proceeding. So they're trying to use the Justice Department to make knowingly false claims. We've got co-conspirator 4 being brought in to the White House. Now, co-conspirator 4 is going to have some significant ethical issues as an attorney making these kinds of decisions. Again, ethical concerns are not a legal charge. That's not a crime, but it could certainly, you could lose your license. It's definitely possible to come in and have charges brought later on. But as an attorney, if you are knowingly doing things that are false and wrong, you can get dinged on that pretty significantly. Co-conspirator 4 spoke on the phone with the acting attorney general and lied about the circumstances of his meeting with the defendant at the White House. Now, let's keep in mind, he's not under oath. So if he's lying in this situation, that's not necessarily a violation of the law. Falsely claiming that the meeting had been unplanned. The acting attorney general directed co-conspirator 4 not to have unauthorized contacts with the White House again. And co-conspirator 4 said he would not. Yeah, who is number 4? Let's take a look at that. Let's just review that here so that we get all of our facts straight. We want to make sure we've got everything. Co-conspirator 4, a Justice Department official who worked on civil matters and who, with the defendant, attempted to use the Justice Department to open sham election crime investigations and influence state legislatures with knowingly false claims of election frauds. So we've got a Justice Department official. So I'm not sure if he was an attorney or not, I guess. I had thought he was an attorney. But if he's an official but not an attorney, I don't know. Jeffrey Clark, yeah. See, I don't even know who these people are. That's how little I've been. I'm so just into the document. I don't really go outside of the corners of the four corners of our document here. So, all right. So, is Jeffrey Clark then? Oh, he is an attorney. Okay. Yeah, I really don't know. I mean, I truly just don't kind of look into that. He's gone full conspiracy. Lawyers, they can be liars. True. Yep, absolutely true. Yeah, I really don't. It's terrible, isn't it? I really don't. I stay so close to, okay, they're all attorneys. Very good to know. I just am truly within the indictment and just the court facts. So I don't have any extraneous knowledge. And so this just doesn't list anybody's name. I really have no idea. So, I suppose I probably should look into it, but I just don't. I don't look into that. I just try to stay as impartial as possible. So, okay, good to know. Yeah, he's going to have some ethical issues then. Pretty significant issues ethically. All right, here we go. Next morning, contrary to the acting attorney general's direction, co-conspirator 4 spoke to the defendant on the defendant's cell phone for nearly 3 minutes. That afternoon, called the acting attorney general and said, among other things, we've got a direct quote here, so we must have some kind of a notes that were taken or recordings that were made if we're looking at a direct quote. And of course, this would be admissible in court as well. People tell me co-conspirator 4 is great. I should put him in. Defendant also raised multiple false claims of election fraud. The acting attorney general, acting deputy attorney general refuted. And then the acting attorney general told the defendant Justice Department could not and would not change the outcome of the election. The defendant responded. Again, we've got another direct quote. So this must be recorded somehow or written down in notes. Right. Just say that the election was corrupt and leave the rest to me and the Republican congressman. That's a direct quote. I mean, there's got to be some evidence to back up where that quote came from in order for it to be quoted like this, because, if not, it would just be the defendant responded something to the effect of blah, blah, blah. But as it's a direct quote, it leads me to believe there's actual physical evidence showing these exact words. So that's just the inference there with that. And I wouldn't doubt it. In this kind of a situation, I would have started recording everything. And I have in the past when I have worked in different varying offices where I knew that there were problems. I was mic'd all the time. Better safe than sorry. And it did. It helped me out quite a bit as time went on. All right, here we go. It's December 28th. Co-conspirator 4 sent a draft letter to the acting attorney general. So now we've got this letter that I think we've all heard about quite a bit. Contains numerous knowingly false claims about the election in the Justice Department, including the Justice Department had, quote, identified significant concerns that may have impacted the outcome of the election in multiple states. This is a direct quote, so of course we have the letter. Justice Department believed that Georgia and other states, two valid slates of electors had gathered at the proper location on December 14th, and that both sets of ballots had been transmitted to Congress. That is, Conspirator 4's letter sought to advance the defendant's fraudulent elector plan by using the authority of the Justice Department to falsely present the fraudulent electors as a valid alternative. So now, rather than just having these questions of, well, now we've got questions, we need to send it back to the states, they're actually saying we need to put the fraudulent electors in as alternatives to the legitimate electors. So now kind of our plan has taken a turn here. The Justice Department urged that the state legislature convene a special legislative session to create the opportunity to, among other things, choose the fraudulent electors over the legitimate electors. Now, this is blatantly illegal here. And under the cloak of the Justice Department. So that's pretty significant. Pretty significant. All right. So the acting deputy attorney general promptly responded to co-conspirator 4 by email. Again, we've got another piece of evidence. Told him that his proposed letter was false, writing, and we've got another quote here. So that just means we've got direct evidence. Despite dramatic claims to the contrary, we've not seen the type of fraud that calls into question the reported and certified results of the election. In a meeting shortly thereafter, the acting deputy attorney general again directed the co-conspirator 4 not to have unauthorized contact with the White House. So this again is going to be these guys testifying to that information. December 31st, the defendant summoned the Oval Office of the acting attorney general, summoned to the Oval Office. Again, this idea of being summoned, can I take a moment and ask what that's about? Do we have this? Yes, eliciting felonies is not good. That's not so good. But this idea that he's being summoned has this negative connotation to it, though, doesn't it? Like, was he given a direct order then that he's like, I'm not going to show up? And they're like, well, you better show up. I mean, what's going on with that kind of, it was a call. Okay. Yes. Well, yeah, right now I'm talking about this idea here. The defendant summoned to the Oval Office the acting attorney general. I mean, that's pretty significant to say, not a legal summons. Okay. Yeah, mob boss. I mean, what kind of language is that he was summoned? I'm just curious about why they use that particular kind of language to illustrate this piece here. So I don't know. I just find it interesting. And other advisors. In the meeting, the defendant again raised claims about election fraud the Justice Department officials already had told him were not true. And the senior Justice Department officials reiterated were false and suggested he might change the leadership in the Justice Department. Now, this is another significant part because he's going to have people testifying saying, the defendant said he didn't like that we were saying there was no fraud, and then he was saying he's going to change the leadership. That's going to be some pretty significant testimony. Retaliation. Exactly. A formal request. You can't say no. That's what I was wondering. I mean, it has a specific meaning in the military, so that's why I wasn't sure Um, yeah, he's threatening, it seems like he's threatening their jobs. Now, there seems to be a lot of that. Like he got rid of the CISA guy. He told he's already saying here, like, um, yeah, he's saying, maybe I might need to change the leadership because they're saying there's no fraud. I mean, that's hinky. That's the legal definition. Yeah, I'm wondering. I mean, I never saw the show, but I mean, I know the tagline to it, and I keep thinking like, wow, you can't do that in real life. I mean, is that really what's going on here? I mean, I don't know. I don't know. He fired a lot of people from that administration. Yeah, yeah. I mean, I knew that there were a lot of kind of in and outs, but that's pretty significant here. Okay, for these guys, when they're testifying, they're going to say, yeah, we went in, we said there's no fraud. He said, we're going to get rid of you. So I don't know, that's not looking very good. All right, just 4 days before Congress's certification proceeding, co-conspirator 4 tried to coerce the acting. Now, this again is an illegal act in and of itself, to sign and send co-conspirator 4's draft letter. This co-conspirator 4 person, I don't know who he is. I mean, you've told me his name, but I don't know who that is. But that's bad business there for that dude. Draft letter which contained false statements to state officials. He told them that the defendant was considering making co-conspirator 4, oh, thanks for the star, the new acting attorney general. Now, this is pretty significant too, as well, because he's saying, hey, I'm going to make you the new acting attorney general. But he's declining that. So he's like, oh, no, I couldn't possibly. Like, what is that? What is that? And who are we going to have that's going to be able to testify to that? It was a bribe. Ooh, good point. Was it? Some kind of quid pro quo? I don't know if anyone knows that. Yes, quid pro quo. Exactly. I'm wondering. It's possible. I think it could be argued, but he said he would decline the offer. So we've got some kind of an offer. If, and again, only if the acting attorney general and acting deputy attorney general would agree to send the proposed letter to the targeted states. Now, this is a threat. So if you don't send this letter, I'm going to take over as the attorney general. Like, what? Is this a movie? Are we in a movie right now? That's kind of how it feels. The Justice Department officials refused. Thank goodness for that. I mean, this doesn't even seem real, does it? Yes, it is. It doesn't seem real. It doesn't seem real that this man, whoever he is, said, if you don't put my letter out that's false, I'm going to take over as attorney general. I mean, now things are really taking a dark turn here. Because of that. I mean, it really is like, who does that in real life? Who actually says that in real life? It's really like, oh my goodness. All right. So I'm just taking to pause for a moment here that this is just like, how is this actually something that happened? But okay, moving on. Next morning on January 3rd, despite having uncovered no additional evidence of election fraud, so here we've got January 2nd. Now we've got January 3rd. In between, there's been no election fraud discovery. Co-conspirator 4 sent to a Justice Department colleague an edited version of his draft letter. He's spending too much time on this letter. All right, I've said it. I said it and I stand by it. Too much time on this letter, which included a change from its previous claim that the Justice Department had concerns to a stronger false claim that, quote, as of today, there is evidence, which is false, significant irregularities that may have impacted the outcome of the election in multiple states. So that is a significant upgrade on that letter of how much he's trying to push this letter through. I mean, that's pretty bad. 45 pages hoax. Well, maybe, but I mean, there'd be like 20 years prison for everybody involved. I mean, that's a lot. That's pretty high stakes for something at this level. What page are we on? 30, but I'm skipping through. I'm going to be skipping through a lot of this. I've been going through the, move it over a little bit. Sure. Let me see if I can straighten it out a bit. Sometimes I don't realize when I'm tipping it to the side a little bit. Let me pull my camera up too. See if that's a bit better. How's that? Is that better? Oh, I do. I try to be resilient. I try. Okay, good. Thank you, Caffeine Cowboy. Appreciate that. Oh, oh, sweet. Yes, yes, you're welcome. Oh, to the left just a bit. Let me see if I can. Hello, Paralegal Life. How are you? Welcome, welcome. We're having fun. Well, I mean, fun is maybe not the right word. We are investigating. Any, yeah, there's so many words in that particular comment. I don't even know how to respond to that. Yes, yes. Oh, absolutely. I think, I do. Okay, good, good, good. Oh, well, yeah, I think it's good to kind of go through and get the facts. So, oh, Philippines, welcome, welcome. Okay, so let's kind of we're going to skip through this here. I'm really just pulling up the direct quotes. So what's going to be used as actual evidence in trial. So that's really kind of how I'm looking at this. We're kind of going through thank you. We're going through these freedom of speech questions to the left a touch. All right, let me see if I can get it. But we're going through these freedom of speech questions. We're going through like what the elements are that are involved in the actual charges. So we're kind of going to that. Tell me why and what circumstances judges can have gag orders. Well, that's a great question, and it's completely left up to the judge's discretion. The judge will determine whether or not a due process will be in question or a fair trial will be in question. And based off of that, they'll issue a gag order in order to make sure we have a fair trial. So, okay. All right. So this one's significant here because we've got co-conspirator 4 and he's pretty, this guy's questionable. Again, I don't know who he is, but if he's an attorney, this is a bit questionable here. So met with the defendant at the White House, again, without having informed the senior Justice Department officials, which is not a crime. I don't know how that would be a crime, and accepted the defendant's offer that he becomes acting attorney general. So this is suspicious because we have someone who is trying to get this letter that he is really working hard on passed, even though it's completely false, and he's trying to send it to the states. So co-conspirator 4 spoke to the Deputy White House counsel. The previous month, the counsel had informed the defendant there's no world, no option in which you do not leave the White House. So it sounds like the White House counsel's pretty clear. Now, that same Deputy White House counsel tried to dissuade co-conspirator 4 from assuming the role of acting attorney general. Now, let me pause here for just a minute. If we just take a minute, can you imagine being this Deputy White House counsel and you're talking to co-conspirator 4, whomever this dude is, and he's saying like, the president of the United States just asked me to be acting attorney general. I think I'm going to do it. Can you imagine what that conversation would be like? It's fascinating to me. And so now the Deputy White House counsel is in this position where he's having to say to this guy, oh my gosh, I'm not sure that's the best course of action here. I can't imagine. I can't imagine how hard this would have been for this counsel here. I mean, how surreal would it be to go through that? Yes, they were going to quit. Yeah, high blood pressure. I mean, and reevaluating your life. Yeah, I think my whole life would have flashed in front of me if I'm looking at some guy that's like, I've got this false letter. I'm going to go forward with this stuff. And the president's just said, hey, why don't you be the attorney general? And I'm like, sure, go for it. That would completely freak me out. So he comes in and he says that there had not been outcome determinative fraud in the election, that if the defendant remained in office nonetheless, there would be riots in every major city in the United States. Imagine that thought going through your mind in the White House. And you're looking at someone who's about to take over the most powerful legal position in the country. It's just like, it blows my mind. And then he responds, well, Deputy White House counsel, that's why there's an Insurrection Act. Okay, and now my mind has exploded. And that is absolutely ludicrous. I mean, that Insurrection Act, when you use military force to put down citizens who are protesting. I mean, what? I feel like this guy escalated very quickly. It really, yes, martial law, exactly. It really escalated quickly. He went from drafting this letter to redrafting the letter to threatening the attorney general and deputy attorney general and saying, hey, if you don't do what I say and send my letter, I'm going to take your job, to trying to take the job, and then having White House counsel trying to say, no, seriously, you don't want the job, to threatening the Insurrection Act. I mean, this is just escalation levels of, it's a lot. It's a lot. It's a lot of escalation. The podcast. Oh, goodness. Well, maybe it is. Maybe it is being misread. I mean, it's possible. But when I look at this, I see quotes here, which means there has to be evidence of this exact wording that can be shown to a jury. So I'm just, I mean, it's mind blowing to even put these words out into the world and saying, well, if they don't like it, then we're going to call in the troops. Like, what? Oh my goodness. Yeah, I think this was quite a bit bigger than what we thought it was. So, okay. Yep. This is a moment. This is a historical moment. And this particular person, like, I don't want to pick out people. This is an indictment. We've got probable cause here. We don't have proof beyond a reasonable doubt, but I've got concerns about this guy. Like, I've got concerns about everybody involved, but this particular person, this level of escalation from this, letter all the way up to the Insurrection Act, he's got some plans. It seems like there were some plans here. Yeah. All right. So, co-conspirator 4 met with the acting attorney general, told him the defendant had decided to put him in charge of the Justice Department. I mean, that's horrific right there. The acting attorney general responded he would not accept being fired by a subordinate and immediately scheduled a meeting with the defendant that evening. And good for him. On the evening of January 3rd, the defendant met for a briefing on an overseas national security issue, and then we can go through that. They had the briefing. They said, don't get involved. He said, fine. Again, another direct quote, which means we must have some kind of documentation that sets out this exact wording. I'm trying to make sure I get this back into frame properly when I flip pages. I tried to organize this a little bit better, so I'll just keep my eye on the comments to make sure that I'm in frame for everybody here. So we've got, yes. Okay, good. Thank you, Matthew. Appreciate that. Yeah, you're right. It's too late for us. We're going to give that to the next guy. We've got people then that are going to testify to this statement. Moved immediately to a briefing meeting with the acting attorney general had requested. Co-conspirator 4, acting attorney general, acting deputy attorney general, Justice Department's assistant attorney general, for the Office of Legal Counsel, the White House counsel, the deputy. Okay, so let's track these guys. Okay, we've got co-conspirator 1, who is that's deeply disturbing to me. 2, again, this is probable cause. 3, we have four attorneys now. Justice Department's assistant attorney general for the office, White House counsel, deputy White House counsel, and a senior advisor. So we have 7 attorneys in this room. The most powerful legal people in the country right here. At the meeting, the defendant expressed frustration with the acting attorney general for failing to do anything to overturn the election results. The group discussed co-conspirator 4's plans to investigate purported election fraud and to send his proposed letter to state officials. Copy was given to the defendant. Defendant relented in his plan to replace the acting attorney general with co-conspirator 4 only when he was told that it would result in mass resignations of the Justice Department and of his own White House counsel. So this is what it took in order to kind of pull them back down from appointing this co-conspirator 4. That's a lot. That's really a lot. I mean, the entire top levels of the Justice Department and White House counsel were all in together saying, if you put in number 4, we're done. So that's a lot. I mean, and each one of these people can testify in court about what happened. Absolutely. Yeah. I mean, that's really significant. And I would think, wouldn't you think a jury would find that significant too? If they called these people up on the stand and said, hey, tell us about this meeting. And they walked through and explained, well, we were all going to walk out. I mean, that's some pretty significant information that, the jury would take that into consideration. I don't know. I think that's pretty significant showing. Co-conspirator 4 suggested Justice Department could opine the vice president could exceed his lawful authority. Again, boy, this conspirator 4 guys really lawful authority during the certification proceeding and change the election outcome. When the Assistant Attorney General and for the Office of Legal Counsel began to explain why the Justice Department should not do so, the defendant said, quote, again, so we've got to have documentation of this direct quote. That's why it's in quotations. No one here should be talking to the vice president. I'm talking to the vice president, and ended the discussion. Yes, conspiracy. Yes. I mean, that's a lot. It's a lot. I don't think there's any way to get around that it's so much. Attempts to enlist the vice president to fraudulently alter the election results of January 6th certification proceeding. Again, this just goes to that original charge of obstruction of a government proceeding. So they're going to go through and explain here the certification proceeding. I'm not going to quote every single word here, but widespread anger and resentment. Here we've got quotes, big protest in DC on December 6th. Be there, will be wild. Again, this particular statement is not going to be protected by freedom of speech because it's on a social media network. Urging supporters to come to DC on January 6th. Retweeted a memo, Operation Pence Card, falsely asserting, again, Vice President could, among other things, unilaterally disqualify legitimate electors. Now, again, with this heavy emphasis on the Vice President's role during that proceeding, that shows, again, that obstruction. So if we just look at what they're asking of the Vice President, obstructing, influencing, or impeding any official proceeding or attempting to do so. So this is where we could get that attempt element. We're attempting to influence the vice president to do something during this official proceeding that's outside of the scope of what he should be doing. So that goes to those elements in that particular piece. Why did they change the law in reference to the vice president if what he did was unlawful? I have no idea what you're talking about. I have no idea about that law. Right. You don't have to succeed to be exactly. And that's really what our inchoate defense is about. You don't have to exceed in the homicide to be charged with attempt. You don't have to succeed in the conspiracy to be charged with conspiracy, and you don't have to succeed in the solicitation to be charged with solicitation. That's how our own inchoate offenses work. Those are, again, just basic criminal, the foundations of criminal law there. On the same day, co-conspirator 2 circulated a 2-page memorandum outlining a plan. So we are going to have that memo. Boy, for attorneys, they really put a lot of stuff down in writing. Have you noticed that too? I mean, that's just something I've noticed, maybe because I've been chatting about this for a few hours now. But I mean, there's a lot of stuff in writing here. There's a lot of documentations that have been put into place, which I'm noticing. I don't know. Yeah. And it reminds me, just as a quick side note, if anyone remembers O.J. Simpson, and O.J. Simpson, of course, very famous criminal civil case. But then we had the criminal situation in Las Vegas. And I remember the judge saying, Mr. Simpson, you have to understand everything these days is recorded. Everything. And for your first trials, nothing was. But now everything was recorded. And so that's our evidence. And it seems like we've got a lot of that. Yeah, there's a lot of paper trail. Like I'm afraid to email customer service. I'd rather call them up and be like, hey, what's going on? Rather than leading a paper trail. That could just be a me thing. All right. So in the memorandum, co-conspirator 2 claimed the 7 states had transmitted 2 slates of electors and proposed the vice president announce that because of the ongoing disputes in the 7 states, no electors could be deemed validly appointed to the states. So that again is a direct obstruction of that proceeding. He acknowledged that he would be violating the federal act, advocating that in the end, Pence then gavels President Trump as reelected. So this is specific, actionable things that they are wanting to do in order to hinder and obstruct that proceeding. So I'm trying to make sure again that I'm in frame here, hopefully. Just 2 months earlier, and then again, we've got evidence of what his prior motivation had been. So, oh yes, VC, you're amazing. Oh my gosh, I'm so thankful. I'm so thankful to my moderators. Always, always very thankful. All right, so several private phone calls. Defendant repeated knowingly false claims of election fraud and directly pressured the vice president. So this pressuring of the vice president, again, is because of his role that he has to do January 6th, which again is this obstruction of that official proceeding. So they're showing via this evidence the different ways he attempted to persuade the vice president. We've got December 25th, where he's saying, hey, help us out. And he's saying back, I don't think I can have the authority to change the outcome. Again, we've got documentation of this. He's got notes saying again, the Justice Department was finding major infractions, which was false. He berated him because he had learned the vice president had opposed a lawsuit. And saying again, you're too honest. And this is all going to be records that were kept by the vice president, I'm assuming, and all would be, admissible in court. So we could bring that in to show again how the president was pressuring the vice president to do something regarding January 6th in the proceeding there. Within hours, the defendant reminded his supporters to meet in Washington. That shows that connection between what he's trying to get the vice president to do and bringing in people to support this hindrance or obstruction of this proceeding. So it'll be at 11 a.m., January 6th. Locational details, stop the steal, and we can assume what that inference means as well. So it's not pressure just because someone requests someone else to do something. Well, typically true, but I think if the president of the United States is asking you to do something illegal, that's like a lot of pressure. You know what I'm saying? I mean, I think if it's just Joe Schmo down at the 7-Eleven, fine. I'm not going to buy a Dr. Pepper, but you're the president of the United States asking the vice president to change his legal duties when it comes to certifying the election? I mean, what? Yeah. I mean, I think that's some pressure. That's a little bit of pressure. It's not illegal to ask for an investigation. No, it's not illegal to ask, but when you take it together with how many times and who all told him that there was no fraud and he continues to go forward, maybe not believing them, which is fine. And then the vice president says specifically to him, I don't think I have the authority to change the outcome. And he continues day after day after day to talk again, over and over and over again, every day to the vice president about this certification proceeding. And the vice president had an absolute right to reject electoral votes and the ability to overturn the election. Like over and over and over again, day after day after day after day, he's asking the vice president to do that. Now, again, probable cause, but I mean, that's some pressure. That's some pressure being put on there. And again, if we're looking at the totality of it, maybe if it was just one time, he's like, I don't think I could do it. And the president could be like, okay, that's fine. But no, he came back the next day and he said, hey, let's do this. And he's like, I really can't. And, you're too honest. And he's saying again, even your own attorneys are telling you I can't do this, but he's just repeatedly asking him. So, I think there's something to be said about that when it's repeatedly being asked of someone and that person is drawing boundaries, right? The vice president's like, these are my boundaries. I am not going to do this. And the president's continuing to ask him that. I mean, that seems like a lot. It seems like a lot to me. That's so ridiculous. Well, this whole thing seems pretty ridiculous and awful and absolutely awful. And I wish this wasn't happening. Yes, using your position of power to intimidate others. Of course, of course. And Pence does have receipts. He does. He really does. That's why we've got direct quotes. Still political speech to advocate for your base to call out Pence. I think we're in a difficult spot because political speech, if you're asking someone to do something illegal, that's not political speech. That's illegal conduct, So he's asking him to overturn or not count the electoral votes correctly. I mean, that's illegal. That's just against the rules. We've got an act, the ECA Act in specific, that outline what the rules are for the proceeding. And he's saying, don't follow that. Again, it's contrary to this federal act. But, okay, we had a meeting again, co-conspirator 2. He excluded his White House counsel from the meeting. Remember, his counsel was in that other meeting where everyone said they were going to quit. I'm skipping here. So he's going through direct quotes again, talking about how we won every state, Pennsylvania voting questions. Vice President challenged co-conspirator 2 on whether the proposal to return the question of the states was defensible. Co-conspirator 2 said, well, nobody's tested it. Like, what? The vice president then told the defendant, did you hear that? Even your own counsel is not saying I have the authority. I think that's significant. I think, again, this goes to this idea that he's being asked over and over and over again to do this. And he's saying, look, dude, your own lawyers are saying I can't, but you're still asking me. And then the defendant's like, well, that's okay. I prefer the other suggestion of the vice president rejecting the electorals unilaterally. So now we're not even in a question of saying, oh, I think there's some question. Let's send it back to the states. Now he's saying to the vice president, okay, we'll just go ahead and reject them completely unilaterally. Let's just do that. It's like, what? If that is in fact true. But again, we've got a quote here, which to me would lead me to believe we've got documentation of those exact words. All right, so, okay, senior advisor, no court would support his proposal. Let me make sure I'm back in frame again. I'm trying to make sure I'm here back in frame again. Yes, Pence did write everything down. He did. He absolutely did. All right, there we go. Move a bit to the left. Okay, here we go. How's that? There is zero intent. He believed something. Maybe. I mean, those are the issues that we argue out in front of the jury. What do you think? Did the defendant intend it? Did he not? Did he believe it? Did he not? What was going on? Those are our fact finder questions. Absolutely left up to our jury. All right, so we've got, you're going to cause riots in the street. It's not going to work. Direct quotes there. Disastrous situation where the election might have to be decided on the streets. So this is all not good. Defendant encouraged supporters to travel to Washington. Now we get into the specific dates and encouraging supporters to come in order to support the plan that had been put into place, according to this indictment. Here are the tweets. The vice president has the power to reject fraudulently chosen electors, which is completely false. Within 40 minutes of the defendant's earlier reminder, see you in DC. So they're trying to place this idea that he's saying, come to DC because the vice president has the power to reject this. So that's the inference there. Washington's being inundated with people who don't want to see an election victory stolen. So there's the implication there that something bad, negative is going on. Our country's had enough. They won't take it anymore. So this could be seen as inciting language. We hear you and love you from the Oval Office. Again, using his position as well to be supportive of, or to kind of give credibility to this idea that something has been stolen. He's in the Oval Office asking about that. So the last tweet here, again, I need to put a little marker up here so that I put this back into frame properly each time. 5:43, we will be speaking at the Save America rally. So that's kind of inciting language, isn't it? That the implication is that it needs to be saved. Tomorrow at 11 a.m., arrive early, doors open at 7 a.m., big crowds. So again, this could be that question of inciting. Okay, good. This incitement to lawless action, and that lawless action would be hindering that official government proceeding. On the 5th, he met alone with the vice president again. So he's meeting again with the vice president when the vice president refused to agree to the defendant's request to obstruct the certification. The defendant grew frustrated. So he's been going after the vice president then since January 25th, or since December 25th. Told the vice president he would have to publicly criticize him. Upon learning this, the vice president's chief of staff was concerned for the vice president's safety and alerted the head of the vice president's Secret Service detail. Now, again, we've got a witness here. We've got another witness here. Now, the vice president is playing this significant role in this proceeding that's being obstructed. So he's playing this pivotal role, and the evidence showing an obstruction of that proceeding can come from the vice president's testimony about what he was asked to do during that proceeding. That's going to show obstruction. The crowds begin to gather. They were audible from the Oval Office, and he said they're going to be angry. So that's him acknowledging the people in the audience. That night, defendant approved and caused defendant's campaign to issue a public statement. The vice president and I are in total agreement. The vice president has the power to act. Again, really putting this pressure on that vice president because of his role in this proceeding. On January 6th, starting in the early morning hours, the defendant again turned to knowingly false statements aimed at pressuring the vice president to fraudulently alter the election outcome, raised publicly the false expectation the vice president might do so. So we've got on the date itself, 1 a.m., the vice president comes through for us. So now we've got some pressure that he's putting onto a person again. Now I bring this up because we have another code section here. Let me just... Oh, it's not listed. Oh, okay. Well, the code section that I think would apply is not actually listed, so that's not been charged. So I'll keep that to myself then. This could be another violation, is what I'm noticing out of this particular section. Yeah. So let me just, not charged yet. Let me just, give me just a minute here. Let me pull this code section that I'm looking at, and maybe you all can kind of help me take a look at it. So just a second. Let me see here. I just pulled this code section up and found that whomever knowingly uses intimidation, threats, or corruptly persuades another person or attempts to do so, or engages in misleading conduct towards another person with the intent to influence, delay, or prevent the testimony of any person in an official proceeding, cause or induce a person to withhold testimony or withhold a record, document, or other object from an official proceeding. This is where I'm wondering. Withhold testimony or withhold a record. That's where I'm looking right now, is this idea that there's intimidation, threatening, or trying to persuade someone to withhold records and documentations from an official proceeding. So this is let me just clarify what I'm looking at here. 18 U.S. Code 1512, tampering with a witness, victim, or informant. And I'm looking at subsection B, 1 is kind of what I'm looking at. So I think that's an interesting piece. It's not been charged, but we've got some elements. Who do we call to add the charge? He's not a witness, no, but I would say here, if we look to this language, you don't necessarily have to be a witness, but if you're persuading another person or attempting to, or engaging in misleading conduct with the intent to cause or induce a person up here, we're trying to influence a person to withhold testimony, or we're causing or inducing or withhold a record from an official proceeding. So the key piece with this tampering isn't that he's a witness, but that he's a person who has some actions within an official proceeding. So I don't know. I mean, I'm just kind of tossing that out there because it was charged in his other. So we've got, I don't know. I think that's a question to ask. Oh, sure. Yeah, I mean, I don't know. It just, for me, when I'm reading through that, all of the elements are dinging in here for, and again, this is what was charged in the Florida documents case. So this isn't for this case, but I don't know. I mean, if we're looking to the U.S. Code, we've got some interference here. So I don't know. Just a question just came to my head. Thought I would share that. All right, so at Mike Pence comes through for us, we will win the presidency. Many states want to decertify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures, which it must be. Mike can send it back. So we've got some pressure here on what he can. Oh, you're welcome. You're very welcome. Yeah, no, we're just chatting about it. We're just chatting about it, figuring it out. We're just talking about it. We're not causing any trouble here. But yeah, I mean, could be seen as some kind of he's trying to say those kinds of documents, what you normally need to do in the proceeding, you need to maybe not do. So that's some kind of tampering in this situation. At 8:17 a.m., the defendant issued a tweet that falsely stated states want to correct their votes, which they now know are based on irregularities and fraud plus corrupt process, never received legislative approval. All Mike Pence has to do is send them back to the states and we win. Do it, Mike Pence. This is the time for extreme courage. So again, all Mike Pence has to do is send them back to the states. So he's saying here the votes received that were sent in, mailed in to Mike Pence, these documents, he's saying send the documents back to the states and we win. So do it. And again, that brings up this question, knowingly uses intimidation, threatens, or corruptly persuades another person or attempts to do so or engages in misleading conduct towards another person with the intent to cause or induce any person to withhold testimony or withhold a record, document, or other object from an official proceeding. So, I mean, isn't it following that he's asking him to send these documents, these certifications, back to the states and keep them out of the official proceeding? I mean, I don't know. Again, I don't know. Okay. Well, I think it's, oh, yeah. Yeah, I mean, if we're hindering him from doing what he needs to do within that official proceeding, I think we've got some more charges potential. But of course, you're going to want to go with your strong charges right out the chute, especially in a case like this. So, all right, let me make sure I'm in frame again here before I go further. All right, so we've got, let's see, on the morning of January 6th. So this is the date of the actual proceeding that's being charged. Again, just as a friendly reminder, I think it's so important that we look at the code section that's being charged here. Otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. So The proceeding is taking place on January 6th. An agent of the defendant contacted a senator to ask him to hand deliver documents to the vice president. The agent then facilitated the receipt of the senator's staff of the fraudulent certificate signed by the defendant's fraudulent electors in Michigan, Wisconsin. And then we've got a text message. We're going to have evidence of that, arranging for delivery of what the senator's staffer had been told were alternative slates of electors in Michigan and Wisconsin because the archivist didn't receive them. The vice president's staffer rejected them. Again, we've got I've said it before, I'll say it again, we've got a side hero here. 11:15 a.m. called the vice president again on, oh my goodness, and pressured him to fraudulently reject or return Biden's legitimate electoral votes. And that's another situation where we're trying to kind of influence, obstruct the official proceeding, which is what he's being charged with. So the vice president again refused. Immediately afterward, the defendant decided to single out the vice president in public remarks. So that could be seen as some pressure. Reinserting language he had personally drafted earlier that morning. I think the fact that they use the term personally drafted goes to intent as well. Falsely claiming vice president had authority to send electoral votes to the states, but the advisors had previously successfully advocated be removed. So I think that's an important piece. Now, we've got more information intensifying the pressure on the vice president to fraudulently obstruct the certification proceeding, which again is the reason why we've got charges here. Co-conspirator told the crowd. So now are we inciting a lawless action? We'll see. Let's take a look at that First Amendment question. That the vice president could, quote, cast the ECA aside and unilaterally decide on the validity of these crooked ballots. He also lied when he claimed to have letters from 5 legislatures begging us to send elector slates to the legislatures for review and called for trial by combat. I don't know any more inciting words for a lawless action than asking for trial by combat. I mean, is there? I mean, seriously. I mean, what else could be inciting other than to say trial by combat? That's pretty significant. Just words alone, just looking at the words. When we're looking for that imminent lawless action, and the likelihood of that to happen, he's saying trial by combat to a crowd. So that, I think, already gets us past the Brandenburg versus Ohio test for freedom of speech. Yes, exactly. It does. It really does. Come on. We're not back in the 1300s. What are we talking about here? Now, you can advocate violence to some degree under Brandenburg, and you could say, let's learn about our government and how we want to change it. But if it's an imminent lawless action, that First Amendment is not going to cover you. Co-conspirator 2 told the crowd, all we are demanding of Vice President Pence is this afternoon at 1 o'clock, he let the legislatures of the state look into this so we get to the bottom of it and the American people know whether we have control of the direction of our government or not. Now, this would be seen as a confession to say we're asking the vice president to obstruct this official proceeding. I mean, that right there is a confession. We know... Ooh. Okay, here we go. Oh my gosh, I've been at this for a while. For all of you that have been with me this whole time, oh my gosh, thanks. We no longer live in a self-governing republic if we can't get the answer to this question. So again, we're looking to see, is this language that's inciting lawless action under the Brandenburg case? So, thank you. Thank you so much. Oh, yes. That's yes. So we've got, you got here page 14. Oh my goodness. Oh, I'm so thankful to all of you for hanging out with me and going through this. You have such wonderful additions to all of this. So thank you, thank you. All right, so here we go. Let's get back. This is serious business here. Let's get back to our serious business. We've got some inciting language here. Again, we found out under the Brandenburg test that freedom of speech is not going to apply. Now we're breaking it down hour by hour. 11:56 a.m. Knowingly made false statements regarding that federal government function. This language is essential to those sections of the code that he's been charged with. To interfere with others' right to vote, and that goes to those fundamental defrauding and fundamental rights being deprived under the Civil Rights Code section. Repeated false claims, election fraud. The defendant's knowingly false statements for these purposes included, and then we've got these statements here. So now he's in public saying these statements. Let's see if we've got Brandenburg here as well. The defendant falsely claimed that based on fraud, the vice president could alter the outcome of the election results, stating, "I hope Mike is going to do the right thing. I hope so. I hope so." So this would be a tampering question. Because if Mike Pence does the right thing, we win the election. All he has to do, this is from the number one, or certainly one of the top constitutional lawyers in our country. He has the absolute right to do it. We're supposed to protect our country, support our Constitution, protect our Constitution. All right, so right here, he's advocating, his thoughts on the government, which again, under Brandenburg, that's absolutely fine. You can do that. Let me just pull up the Brandenburg test as we go through this First Amendment analysis. So, freedom of speech in the press do not permit the state to forbid advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action, and that is likely to incite or produce such action. So this is what is not protected, okay? Now, we've got a couple of things, though, because when he's talking here, he's not being charged with a violation of a criminal syndicalism law. We're not charging him with that. We're charging him with interfering and obstructing an official proceeding. So this is the law. So if he's trying to claim him being charged here is a violation of his First Amendment freedom of speech, we're not talking that the content is being limited. We're saying he's interfering with a proceeding. So just kind of keep that in mind. So these words he's using here are not what we're really looking at. What we're looking at is the result that made them have the proceeding was halted for 6 hours, was pushed back because of the language he used. And if he's going to say freedom of speech, he's going to say that statute, that section of the code is illegal and a violation of his First Amendment freedom of speech. That's what he would have to do in order to use a freedom of speech defense in this case. So states want to revote. The states got defrauded. They were given false information. They voted on it. Now they want to recertify. They want it back. All Vice President Pence has to do is send it back to the states to recertify, and we become president, and you are the happiest people. Again, this is the language used in order to obstruct, influence, or impede an official proceeding, or attempting to. So that's what this language is about. So it's not about, hey, I don't like the government, let's switch things up. No, it's that we have an official government proceeding, the casting of the electoral votes, that's going to be interrupted because of this language that's being used. All right, so that takes the First Amendment argument off the table. Okay, as a legal theory. So that's what we're talking about when we're talking about the Brandenburg test. After the defendant falsely stated that the Pennsylvania legislatures wanted to recertify their votes, they want to recertify, but the only way that can happen is if Mike Pence agrees to send it back. Again, this language is interrupting an official government proceeding. That is why there is a charge. It's not because he's raising this issue or he's saying, hey, there are bad votes and there really weren't any. The issue is he's saying it, and this crowd then is going to go forward and interrupt an official proceeding. That's where we have the charge. All right, and that takes us then. The defendant said that regular rules no longer applied, stating, and fraud breaks up everything, doesn't it? When you catch somebody in fraud, you're allowed to go by very different rules. Again, is this inciting language? Is this language meant to kind of stir the crowd up in order for them to assist him in obstructing the proceeding? That's the question. That's the legal question. I don't have the answer. I'm just asking the question. Finally, after exhorting that we fight like hell. Again, we've got some inciting language. And if you don't fight like hell, you're not going to have a country anymore. That language itself, again, I mean, what's the inference there? That you have to fight. So he's got a crowd in front of him, and he's saying you have to fight or you're not going to have a country anymore. So is that leading to an imminent lawless action? Is that inciting illegal action? Right. Yeah, I mean, that's the question. That's the question the jury will have to decide. We fight like hell, and if you don't fight like hell, you're not going to have a country anymore. This language, if it's inciting an imminent lawless act likely to happen and then did happen, that's for the jury to determine at trial. The defendant directed the people in front of him to head to the Capitol. So now he's actually telling them where to go, suggested he was going with them, and told them to give members of Congress the kind of pride and boldness that they need to take back our country. Now, this particular sentence, the kind of pride and boldness, that to me doesn't seem insightful. It doesn't seem like he's inciting something bad here. But then when you add it to take back our country, now we're looking at a little bit of a different meaning to that phrase. So if we're trying to give pride and boldness to our Congress in order to, do the right thing, great. But we're adding this idea of taking back our country because we're fighting like hell, or you're not going to have a country anymore. So when you take this all together, it could be it seems, it could be seen as inciting. Again, it's up to the jury. It's going to be up to the jury. Fight does not mean violence. You're right. You're right. It doesn't always mean violence. We fight like hell. And, that trial jury, whenever that happens, they're going to have to make that determination. What did he mean by that? We fight like hell. Does fight like hell just mean like a good argument, a good debate, or, a passionate protest? I mean, what did he mean by these words? That's, again, going to be for our jury to determine what's going to happen with that. But I think it's good to ask the questions. I think those are valid questions to ask. What was the meaning of this? What was meant? What was the intent? Were we trying to, in this situation, obstruct that official proceeding by telling them, go to the Capitol? That's where the proceeding was taking place. Tell the members of Congress to take back our country. That's who was involved in the official proceeding. So I don't know. There's a lot of elements at play here. Now, during and after the remarks, thousands of people marched towards the Capitol. The defendant's exploitation of violence and chaos at the Capitol. So, Vice President issued a public statement explaining he can't, unilaterally determine the electoral votes that should be counted and should not. Before he had finished speaking, the crowd began to gather at the Capitol. So now we need to look to the crowd and say, hey, is this reasonable for us to think that there's going to be some imminent lawless action going on? Is that reasonable? After the speech that was given, is it reasonable to think that there could be some trouble here? Again, up to the jury to decide. Therefore, a mass of people, including individuals who traveled to Washington and to the Capitol at the defendant's direction, broke through the barriers. And this is that moment again where we have this interruption with that official proceeding. Off the Capitol grounds, advanced on the building, including by violently attacking law enforcement officers trying to secure it. He concluded his remarks, watched the events from the Capitol, so he knew what was going on. 213, violent advancement. The crowd at the Capitol broke into the building. So again, we have to walk through this process of, was it reasonable to believe that this kind of language that he was using would be enough to kind of incite this level of violence? Was that possible? Again, I don't have the answer to that. That's a question for the jury to decide. Upon receiving news that individuals had